All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning and welcome to the District of Columbia Court of Appeals and our virtual forum. We have 3 cases on the calendar today. The first is 20 CF 298, Gregory Ray Smith II versus the United States. Counsel for Mr. Smith, if you could introduce yourself for the record and let us know how much time you would like for rebuttal.
Thank you, Your Honor. May it please the court, my name is Dennis Hart. I'm here this morning on behalf of Gregory Smith. We'd like to reserve 5 minutes for rebuttal.
Mr. Smith, Mr. Hart, if it's possible for you to get a little closer to the microphone, you're a little faint.
I will ask you if this is better.
It is. Thank you.
The appellant raised 2 issues in his brief. I'd like to begin with the Honda search initially, because if the court agrees with the appellant on that issue, it resolves the case entirely and it need not consider the second laboratory issue. I'd like to begin also with what I think the government and the appellant agree on. The government, I think, will agree that the charge of window tint is insufficient to justify the search of the Honda. The government, I think, will agree that the trial court erred when it mentioned that as a possible basis for the search of the Honda. That leaves only the possession of an open container of alcohol as the basis for the search of the car. But we'd like to remind the court that the POCA search, although admittedly is permissible, is not an unlimited one. It is not a general warrant search, and it should be judged by the reasonable standard of the Fourth Amendment. Now, the government, in its brief, responds that no matter what the court does, its theory is that the search could have been for the arrest of the POCA charge, but that, of course, refers to the defendant himself. What was in the first initial search is that of the Honda. And as I said, that the reasonable standard indicates that the government must demonstrate that the officers either expected to find a weapon in the car for their own safety, they can search, or there was a reasonable belief that they would find evidence of the crime. And if the crime could only be POCA, they have to demonstrate that the possession of an open container of alcohol evidence would be found in the car. Now, they could look at the floorboards, they could look at a bag, but the appellant submits they could not look in a closed and locked, well, I shouldn't say locked, I should say a closed and sealed container, which is where they found the 3 vials of.
Okay, can I just pause for a second so I can understand your argument? Are you saying that the government had reasonable articulable suspicion to conduct a GANT search of the car in a more general way, like excluding the container? Do you think they could have gone in the car to look, to take a look around without opening up any containers?
For POCA evidence, yes.
They could have, okay.
But they did that.
Why? What was the basis for that?
Well, I'm faced with
was there any testimony whatsoever? There was no testimony.
Of what, Your Honor?
From the police explaining what they were doing.
I think
and why they were doing.
I think there was, Your Honor. Now, I must admit I'm very uncomfortable with the procedure that was followed below, and that there was no hearing for the motions. What we have is some statements made by the lawyers, statements made by the trial court, and the trial testimony of the officers who stopped the vehicle. And the officer on the driver's side testified, and the officer who conducted the search on the passenger side testified what they did as far as the search of the Honda. So I believe there is some testimony on that.
I think what Judge Easterly is asking is there's no testimony that they had based on the Remy Martin bottle, that they did not have any particular suspicion that they'd find more accoutrement of drinking because there was no suppression testimony, period. I don't know if it came up at the trial testimony. Did it?
No, I don't believe it did, Your Honor.
Well, I guess it depends on how you say came up, because there is testimony, I thought, at the trial. This is on transcript of page 16 of the December 11th, where the officer explains at least why they searched the vehicle and said they were searching for other liquor, bottles, beer cans, cups, wine bottles, things of that nature. Now, so it sort of came up a little, but I don't know that it came up in the way of an officer explaining why there was any particular reason to believe those things were in the car, but at least there was some reference to why they did what they did.
Yes, Your Honor, that's correct. The trial court in the motions hearing, well, the motions decision mentioned accoutrements several times. And the trial testimony followed that theory, that accoutrements were looked for.
Is it, you made an argument in your brief, I'm just curious, I want to make sure I understand it and whether it'd be clear whether it is an argument you're making. I thought, are you making the following argument, which is other non-open bottles of liquor in the car aren't really even evidence of POCA? How do they support or tend to prove POCA? If they're not open, they're just, more liquor. So how is that relevant to the charge? Is that an argument you were making, or was I reading too much into something you said in your brief?
I don't recall making that argument, but I would if I did. I would agree with that. I think that's a good argument. If I didn't make it, I should have. Because, for example, you go shopping, you bring your groceries home, and if you bought a bottle of liquor, you shouldn't be subject to police intrusion if you're stopped for something. Evidence of POCA is an open container or the accoutrements, which the trial court mentioned.
I'm not sure that's right. I mean, I assume to prove a POCA, I assume you need to at least show that the defendant had knowledge that there was an open container in the car. And if they've got one open container in the car, you might have a more plausible, I didn't know about it, than if you have 7 open containers in the car. So why can't officers look for more, cups, other open bottles, crushed cans on the ground as some evidence that, this was not an innocent mistake. This defendant definitely knew there were open containers of alcohol in the car, whereas a single one, you might have a harder time proving that as the government.
Your Honor, I agree with that analysis. I thought the question was for an unopened bottle.
Oh.
Yeah, I'm not sure. I'm unsure what I think of that argument. I was just kind of curious whether you were making it. I can see the logic of that argument. I can see perhaps some contrary argument that along the lines of the argument Judge Deahl was suggesting, but obviously it would have to be a little bit different if you're talking about unopened bottles. But it could be, in theory, the government needs to prove possession, so knowledge and intent to exercise dominion and control over. And if the issue is an unopened bottle of, or there's one open bottle of type of alcohol X, and the issue is did the defendant possess it, and in the car are 5 other bottles of the same with a receipt that has the defendant's name on it, then you might well think, okay, well, that is some additional evidence of possession. So I can see scenarios where, at least arguably, possession of unopened containers of alcohol could be logically relevant as evidence at a trial of, for possession of POCA. But anyway, I was just curious to try to make sure whether you're making that argument. I gather you're suggesting you're not sure you were trying to make it in your brief, but you are interested in that argument as a possible line of thought. Is that fair?
That's a fair description, yes. In order to avoid the the consequences of an illegal search of the sealed outer box that resulted in the PCP. The government has suggested in its brief that, well, the appellant could have been searched for POCA while he was standing on the sidewalk. And there are a couple things we'd like to say about that. Number one, the government agrees that this is an alternative theory that was not explored by the trial court. Number two, the government agrees that this is a hypothetical theory. Now, the appellant's forced to agree that this court can make a decision on a suppression issue based on alternative theories that the the Superior Court did not use as a basis. But we suggest to do that in this case and adopt the government's theory that what's the big deal? He could have been searched for POCA as he stood on the sidewalk. Is dangerous. It's dangerous because it was never explored at trial or in the hearing so that facts could be established about the search while he was on the sidewalk. It's dangerous because those facts could never be applied to a government theory, which was never proposed at the hearing. And as a result, we suggest the court should not engage in this hypothetical because, again, the test of Fourth Amendment reasonableness applies.
I take your point about the lack of findings, but I thought that the United States did make this argument either in its written file in the trial court. I'm trying to pull that up now, but am I misrecollecting? You think the United States never touched on this sort of alternative, what I think of as in substance and inevitable discovery type argument at the in the trial court?
Well, I'll defer to the court and the government on whether they brought it up in written. I don't recall it in the oral, in the transcript. What I want to say, what I think is important is that even if the search is allowed of the person under POCA while he's on the sidewalk, it still is governed by the reasonableness requirement of the Fourth Amendment. So as a result, the search of the appellant on the sidewalk has to be reasonable for the specific offense in which he's being searched, POCA. Thus, it's important to determine whether they were searching for additional bodies, or additional bottles.
That's right. Is that right? If I understand the logic of the theory, it is once the police saw the open container, they had probable cause to arrest Mr. Smith for POCA. And without having to rely on any additional evidence or justification, they could have searched his person incident to arrest. Not a Gantt search of a car, but instead just a search of his person incident to arrest. So I thought that the steps of this, one of the steps of the theory was search incident to arrest, and therefore there wouldn't really be an inquiry for that step of the process, at least into whether that was reasonable or there was some reason to think there was evidence of POCA on his person. That I think the United States' theory is that's just an accoutrement, if you want to use that word, of arresting somebody. Do you disagree with that?
I do disagree with that, Your Honor, because he wasn't arrested. The fact that he could be arrested is irrelevant to the scope of the search because the scope must be determined by the facts as they were, not as they could have been.
I think Lewis, our en banc opinion in Lewis says otherwise. I think we're talking about, if I'm following the discussion so far, we're talking about the search of Mr. Smith, which is not a Gantt search that is confined to, do you have reasonable suspicion of this particular offensive arrest? It is a more classic, what you might refer to as a Chamel incident search, which is whether you have particular reason to think he's dangerous or that you'll find evidence of the arrest or not, you get to search both his person and the things immediately within his reach. What am I getting wrong?
Under Chamel, it was a search for either dangerous objects or things that could be destroyed or hidden.
Well, no, I mean, Robinson made very clear in the Supreme Court that whether you have particular suspicion of those things doesn't matter. You get to search anyway. I think what the court said was we don't want officers having to make those sort of fine distinctions in the heat of the moment of an arrest. So if you're arresting somebody, and then I think we said in Lewis, even if you have probable cause to arrest and shortly thereafter do arrest somebody, you can conduct a Chimnomnso search of their person without any particular degree of suspicion that they have evidence of a particular crime or a dangerous weapon on them.
This is a pre-arrest search. And for a
That's
pre-arrest-
again, that was Lewis as well. It was post probable cause to arrest. There had been no definitive decision to arrest or not, as I remember Lewis. And I think we have the same thing here. And then an arrest followed quickly on the heels of the search, I think is the language. And that's all true here as well. So the fact that it's a pre-arrest search isn't going to get you where you want, I don't think.
It still must be limited by reasonableness, and a reasonable search would be limited to the evidence of POCA if it's based on a POCA arrest.
That's definitely wrong. In Lewis, it was driving on a suspended license was the offense, and they got to search him. And it's definitely not true that a Chimnomnso search is tethered to whether or not there's reasonable suspicion to think there's going to be evidence of the offense of arrest. That's that, Robinson made that very clear. So I don't know what you're basing that on. You're talking about a Gantt. A Gantt search is different. A Gantt is sort of a new thing, right? It's once the person is secured away from the car, which, by the way, it's not so clear to me that was the case here. But I think the government seems to agree that this is a Gantt step 2 search. Once the person's secured away from the car, you don't get to go into the car under a traditional Chimnomnso type analysis. You need reason to believe you're going to find evidence of the offense of arrest. That's different from the search of the person, where you don't need that at all.
Well, I see that my time is up, but I would respectfully disagree.
All right.
All right, Mr. Hart, thank you very much. We'll hear from the government now. Ms. Kalu.
Thank you, Your Honor. And good morning, and may it please the court, Chimnomnso Kalu on behalf of Abdullah of the United States. In this case, Your Honors, we're asking the court to affirm appellant's conviction. First, it's clear from the record that the trial court did not err in denying appellant's motion to suppress because police had probable cause to arrest appellant for possession of an open container of alcohol, which in turn supported both a search of the car for additional evidence of that offense, as well as it supported a search of appellant's person incident to arrest.
How do we know that if we didn't hear any testimony from the officers to explain what their reasoning is? Or is it perfectly okay just to skip over hearings and let a judge come up with objective reasons that there might be a basis to search a car?
Your Honor, I think in this case,
because that would make suppression hearings a lot more efficient, right? Like, let's just let the judge come up with objective reasons to conduct searches, and never mind what the testimony from the officers on scene is.
So I don't think that the judge here came up with the reasons on his own. Rather, what happened was the judge proposed to the parties that it appeared that appellant's motion to suppress was more of a sufficiency of the evidence question. And the judge asked the parties.
I don't understand that. I'm sorry. It's the government's burden, and the government has to give the court reasons why the search doesn't violate the Fourth Amendment. So I just don't understand. It's a sufficiency question. There's no evidence has been put before the court. So what exactly what would the court be assessing to determine whether it was sufficient if it doesn't have any evidentiary presentation before it?
So, and Your Honor, I use the word sufficiency because that's the word that the trial judge used. But
I understand that you didn't come up with that word. I don't understand the court's analysis. So maybe you could explain it to me.
Yes. So the court asked the parties whether they agreed that the facts were essentially undisputed, and both parties agreed to that. and agreed to proceed via essentially proffer. And so they made their arguments based on the undisputed facts that were both in the defendant's motion to suppress as well as the government's opposition. And additionally, throughout the course of this suppression argument, the government proffered facts concerning the reasons behind the search, what would constitute the reasonable articulable suspicion. And the defense counsel did not offer any objection or
What were the proffered facts about what suspicions these officers had?
Certainly, Your Honor. And I'd be looking, I'd point the court rather to the December 9th transcript of the suppression hearing. The government proffered at page, I believe is 15, that the officers were looking for, I'm looking at page 15 of December 9th, looking for implements of that offense, the offense being POCA. And the government explained that the particular alcohol in this case, which was Remy Martin V, a type of cognac, that it could be consumed in various ways, including being mixed with other mixers or juice poured in a cup. And on the next page as well.
You're looking at page 6, just so I'm sure I'm in the right place. You're looking at page 16 of December 9th?
Page 15 and 16, Your Honor.
Okay.
So on page 15, the government makes the proffer concerning the idea that the liquor could be mixed with other things in cups, and that the officers would be looking for cups. And then on page 16, beginning at line 13, the government discusses looking that the officers could be looking for other evidence, including mini liquor bottles that were open, or further cups in the bag, and shot glasses.
Yes, so let me just pause you there, because I mean, this is sort of the flavor that I get from your brief as well. You know, could be, you know, there could be. Remy Martin is, you can drink it from a cup, you could drink it from a shoe, you could drink it from a miniature hat. Is there reason to think that might be happening here? On that, there's no evidence, there's no proffer, and I don't think there's any common sense intuition that people drink Remy Martin from miniature shot glasses contained in a tiny watch size case. Was there a proffer that officers, like, they've seen that before?
I think what was proffered to the court was that it was reasonable to think, based on the size of the case, that the case could contain something like shot glasses.
It could. There's no question about that. I guess my question is, how is that the relevant question? Is it true that officers have, you know, one of the defining characteristics of a liquid is it will take the shape of whatever you put it into. Remy Martin could exist in any container. It could exist in a small container that's built to hold a single gumball. And if that were not clear, do you think officers could open that up because it could contain Remy Martin? Anything that could hold liquor is fair game if you're searching for offensive POCA. So that's one option, which is why I hear you sort of saying, whereas I would have thought the correct analysis is, well, do you have reason to think this particular container would have more evidence of POCA, not whether it could?
I would, in addition to the case itself, Your Honor, and the proffer that was made about the case, the government also on the previous page, that same transcript, page 15, talked about the black plastic bag in which the case was found, and noted that that type of bag was, quote, the type of grocery bags that are often provided by convenience stores and can hold alcohol. And so I think that with that additional context, as well as the fact, I think if I'm remembering correctly, the exhibit that we supplemented the record with shows there was in fact a cup in that bag. That would add additional reason to think that there could be something like, and specifically a shot glass, because that's what was proffered, and because shot glasses are commonly used to consume liquor, which is.
But I don't understand. I mean, this is along the lines of Judge Deahl's question. There are all these possibilities. But in so many cases, what we hear is, look, police officers are out there on the ground and they know how things work, and you need to trust their experience and their perspective on how things are actually working out in the community and what they see and how crimes are being committed. And it just seems so odd to me here that the government now is like, well, we don't want to put our witnesses on. We don't actually want to have a hearing. And the trial court, whose raison d'etre is to have hearings and find facts, is like, yeah, never mind, we won't have a hearing. Let's just get proffers from lawyers about what is possible. It seems quite bizarre to me that we just skip over that and say, well, let's just do this all on proffer and resolve this suppression hearing about someone's Fourth Amendment rights based on what some lawyers can posit about what possibly could be happening out in the community. Is this now the common practice for the government to just say, hey, we'll do this on proffer?
I think, Your Honor, rather than in this situation, again, the parties agreed to proceed without. And
I don't think the defendant agreed to all of the inferences that you are saying that the government proffered. The defense was saying, my Fourth Amendment rights were violated, and I don't think the government has carried its burden. So I don't see any concession from the defendant that the proffer was going to suffice. Am I wrong? Is there some sort of statement in the record that I'm missing where the defendant said, yes, the basic facts about the sequence of events we agree to, and we agree to all the inferences about what was possible and reasonable? We agree to that too?
So the way that I read the record, Your Honor, is that the attorneys, the government attorneys in this case, proffered based on a conversation with an officer who was available, the facts that I just set out for the court. And upon making that proffer, defense counsel didn't raise any objection. And in fact, later, the court took a recess to consider the issues that were raised in the motion to suppress. And when the court returned and indicated it was ready to rule, the government suggested to the court that perhaps an evidentiary hearing would further elucidate the issues in the case. And I'm looking now at the bottom of 22, where the government talks about making a holding a hearing, presenting testimony, to the top of 23, where the court says, quote, let's figure this out. I thought, Mr. O'Brien, I don't want to put words in your mouth that you agreed to move forward without a hearing. And counsel responded, yes. And I think that
I think there's a difference between not objecting to the failure to hold a hearing and explicitly agreeing to everything that has been said in a proffer. And I mean, what the trial court said on page 20, a couple pages earlier, was, I'm going to decide this on the papers, which seems to be not so much what was proffered at the hearing. So that makes this all a little murky. And then the other question related I have is, I found it quite confusing on 15 over to 16, what part of that was a proffer based on the prosecutor's discussions with the officer who was intended to testify, and what part of it was an argument about what's reasonable. I mean, the prosecutor starts, for sure, indicating that it's a proffer and says some things that are, Officer Minzak's testimony would be. And so there's a beginning, on page 15, it definitely starts out as a proffer. But then the trial court, when you get over to 16, the trial court is like, well, why would you need vials of liquid if you're drinking Remy Martin? And then the prosecutor is not so much saying, oh, and here is a further description of what I'm proffering Officer Minzak's testimony would be. The prosecutor just starts saying what's reasonable to conclude and what the video camera will show. And so I got a little confused or uncertain about how much here actually was a proffer rather than something that was more in the nature of, here's an argument about what a reasonable person could conclude or infer. Do you think it's clear that everything that is said on 15 over to 16 is a proffer about what officer from the prosecutor about what Officer Minzak would have testified to?
I would agree that it could be clearer, but in viewing, in considering the standard of review and viewing the record in the light most favorable to the prevailing party, which here would be the government, I would argue that it is clear that the government was continuing with the proffer from Officer Minzak. And for that, I would actually point the court to the fact, the court may recall that there were actually two prosecutors in this case. And the one who made the representations to the court about speaking with Officer Minzak was the second one who sort of jumped in as the first prosecutor had been talking with the court. And she, said to the court that she wanted to add to the argument based on further up on the page at line 5, she begins saying, I personally have been speaking with Officer Minzak, who is the testifying officer for the hearing, although of course he did not ultimately testify at the hearing. And so I think that in context, it's more that she was providing, the prosecutor was providing her understanding of what the officer's proffer was and less just what was reasonable.
Can I ask? Go ahead.
No, please go ahead.
The appellant cites United States versus Nash, which is quite similar to this case. The government has not responded to it. And I'm curious what the government's response is. And just to remind you of the facts of that case, it was once a companion of Lewis, but it did not get vacated by the en banc opinion. It was a driver by himself with a 20-ounce can of Four Loko. He was pulled over and they searched the car for other evidence of polka. This court said you don't get to do that. There's not reasonable articulable suspicion to think there's going to be more evidence of polka, particularly in light of the lack of testimony, saying things like, yeah, when we find a container of Four Loko, usually we're going to find some other evidence of a polka. To me, it looks almost identical to this case, and I haven't seen the government respond to it. Do you want to provide a response now?
Certainly, Your Honor. I think if I understand what Four Loko is, it's not the same as a cognac in that I believe, and this is based on what I read from, I did review Nash in advance of today, that it's a single serving can, essentially, something like a beer can, as opposed to what we have in this case and what was present in Lewis, which is a bottle of liquor. And I would note for the court also
But that's not really the basis of Nash, though. It didn't say, first there was only one person in the car, both in Nash and here, unlike Lewis, where you might have some evidence to think the alcohol was being shared. 2, it's a 20-ounce can of Four Loko. It's pretty big. You could share it. Number 3, how big is the bottle of Remy Martin here? Has anybody submitted evidence that this isn't a personal flask-sized bottle of Remy Martin? We weren't supplied with body-worn camera. Nobody describes it on the record. What leads you to say this is not a personal consumption size of Remy Martin?
Your Honor, I think that the court is correct. There isn't a picture or a size description of the Remy bottle, but it is like what was in Lewis. Again, it's a liquor. It was found in the center console, and so I think that the type of alcohol is different and is important here.
Don't you think we want an officer saying something like that rather than the three of us or the government sort of intuiting how people consume alcohol in their cars? I mean, I get it. It's not a bad distinction, right? A liquor is more likely to be poured into a cup than a Four Loko. I think that's probably true. But that's just kind of what I think. And you would think you might want an officer saying something like, yeah, when we find bottles of liquor, we're going to find some cups sometimes. Not so true of Four Loko, but instead we have none of that.
There is, Your Honor, of course, the proffers that we were discussing, and also—
The proffers just say, this is what I was looking for. The proffers say I was looking for, that was true in Nash as well. They went looking for more evidence of polka. It doesn't mean they were doing so based on anything more than a hunch.
And Your Honor, I would, all that I will add to that, Your Honor, is that there was also testimony, there was some testimony, not as clear certainly as what was in Nash, but as Judge McLeese pointed to on December 11th at page 16, Officer Zack talked at least about looking for cops, and that they were looking for cops because they had seen the appellant here, Mr. Smith, had picked up the bottle of Remy, shown it to the officers, and that they decided at that point, or they thought at that point, that they might find cups or flasks in the car. He makes reference again to that on page 36 of the same transcript during cross-examination by defense counsel.
Again, to me, it's just missing the link that it was reasonable to do so. You know, we could have an officer saying, when I find polka, so, you know, because I found an open container of alcohol, I decided to look in the trunk for a body. Okay, you know, I'd like to know if there's a reasonable link between those, and here we don't have evidence of that. Saying that because he saw a bottle, he searched for other stuff doesn't tell me if that's based on a lark, based on a hunch, based on his experience, based on good reason. And we don't have anything, like the proffer doesn't speak to that question.
The proffer does not directly speak to that, yes, Your Honor. The officers did testify about their experience, their years on the force and conducting traffic stops and the like. And I just would also like to, if I may, correct a statement that counsel made in his argument with respect to certainly our primary argument is that the open container offense gave the officers the ability that it justified the search of the car, including the black case. The government also did, certainly it's in a footnote in our brief before this court, make reference to the idea that once the appellant had been arrested for the polka, that the officers could separately search his person incident to arrest. And during that search incident to arrest, they found a vial of PCP in his pocket. And the government did actually, briefly, but did make reference to that argument during the suppression argument, which I believe is at page 23 of the December 9th transcript.
Can I just ask?
At page 22.
That reference is a little opaque, but I took it to be maybe an effort to get to this point. I found it a little murky, but I guess my concern is less with whether that idea was mentioned in passing in the trial court and mentioned in passing in your brief in this court, but with whether I mean, we know we don't have a trial court finding on it. Wouldn't, at a minimum, there have to be a finding by the trial court? I mean, the idea would, I guess, be that if you create a hypothetical world where the officers hadn't searched the car first before searching Mr. Smith's person, and you imagine they had gone and searched Mr. Smith's person first, they would have found the vial. The search would have been the same. They would have found the vial. Then they would have gone and searched the car in a Gantt type search on stronger justification, because they would have found like small vials of liquid, and they could go look through the car, including perhaps into the outer box. So that's the logic of the theory. And it might be a good theory, but it seems to me that it couldn't be a basis for us to affirm in the absence of a trial court finding that that's what would have happened in this alternative world. And B, I wonder whether that's something that the trial court could have found on this record, because there's no evidence about it. So it's not as though there was at the hearing testimony or a proffer even from someone that would say, okay, officer, imagine that you hadn't that nobody had searched the car first and found what was found in the otter box. What would have happened? So I just wonder whether that point has been adequately factually developed, and in the absence of a finding also, whether that's a possible ground for affirmance.
Certainly the court is correct. There could have been more factual development as to
I don't mean to be snarky, I guess, but could there have been less?
I think, Your Honor, that there was during the trial some undisputed testimony from, I believe, Officer Jones, that the vial that was found in Mr. Smith's pocket was similar in nature in terms of the caps were the same, that the liquid was the same, and this, that, and the other thing, which could it could at least suggest that there would have been a reason for, and of course this is hypothetical, that the officers would have thought, you know, maybe we'll find something exactly like this in this case.
I mean, you're skipping a step though, right? Was there even testimony that they would have searched him absent discovering the PCP in the car?
That they would have
searched Mr. Smith if they hadn't first found the PCP that was in the car.
Well, I think
that's kind of step one of your inevitable discovery. Well, first, can you just answer, it's not clear to me what kind of argument you're making in this footnote. Is this an inevitable discovery argument? Is it an independent source argument? Is it an attenuation argument? What is the argument you're making? Like, what's the category that it fits in?
Yeah, I think, Your Honor, it's would fit more within an inevitable discovery. And so the officers arrested, they did in fact arrest Mr. Smith in this case. And they would have, in arresting him, searched him incident to arrest, is the argument that we're making. And
doesn't part of your argument need to be, and they were going to arrest him even if they hadn't discovered what they found in the car? And if that's part of, that needs to be part of your inevitable discovery argument, right?
Well, and I think that there is an indication in the record that would have happened. Certainly the Gerstein, which is at the first document in the record in this case, the officers did in fact arrest him for possession of an open container of alcohol.
I know that the Gerstein is part of the record writ large, but did the Gerstein ever come before the court at the suppression hearing? Was it an exhibit?
No,
Did
Your
anyone
Honor.
talk about it? Right.
No, Your Honor.
Do you cite any inevitable discovery cases in your footnote? I believe it's 7.
We don't. I was just in responding to Judge Deahl's question, trying to categorize what sort of what category of search it was closest to. But I think aside from inevitable discovery, as the en banc court, this en banc court found in Lewis, the search and the arrest, if they happen substantially contemporaneously, the fact that the search or the arrest precedes the other does not invalidate the basis for the search. And so here, there was probable cause, as I said at the outset, to arrest Mr. Smith for possession of an open container of alcohol, and they did in fact arrest him for that offense. And so there would have been a search of his person incident to arrest, which would also separately provide a basis to search the car.
Yeah, that seems an assumption to me, and I don't know that the Gerstein, assuming it's properly in front of us for this purpose, sheds much light on it. Obviously, I mean, it's true that after the apparent vials of PCP were found in the car, Mr. Smith was arrested, and he was among the charges he was charged with was POCA. That's true. But if the search was invalid, the search of the car was invalid at the time it was conducted because there wasn't reasonable articulable suspicion to conduct a Gantt search, or because opening up the OtterBox wasn't a reasonable part of a Gantt search, then you need, I mean, inevitable discovery is your alternative argument. And it's not, the chain of reasoning has to be, I think, but correct me if you feel differently, but the chain of reasoning has to be assume what happened was a violation of the Fourth Amendment. Assume a world where it didn't happen, not our world, but a hypothetical world. Assume that, this different world. What would that world have looked like? And the theory would be, well, in that world, the police have seen the Remy Martin, they had the tint violation, and they've got Mr. Smith standing outside the car. And step one of this hypothetical world has to be that they would have arrested him for POCA. and that they later arrest him for offenses including POCA after they find PCP doesn't tell you whether they would have arrested him for POCA if they hadn't found PCP. It just doesn't, to me, it doesn't, it's completely ambiguous as to whether they would or wouldn't have. And then, of course, the question, so that's the problem number one. I don't think the Gerstein tells you much about how that hypothetical world would have played out. That's only step one of the hypothetical world, because step two of the hypothetical world would have to be, then the search incident to arrest would have been the same, which, you know, I tend to think is probably a very likely inference, but in any event, that's step two. And so it would have found the vial of PCP on his person, or the vial that, you know, at least there's a field test to believe may have had PCP. And then step three would be, and then once they found that, the officers would have gone and searched the rest of the car in a Gantt search that would have been lawful. And I mean, again, I think that steps two and steps three seem like pretty natural inferences, although there's no evidence directly supporting them. Step one seems to me much more uncertain. I mean, maybe it's true that officers arrest everybody who they stop for POCA and will stop for a window tint violation, and everybody who they have on POCA, and maybe they arrest them all and search them to arrest. I have no idea really, though. For all I know, that they often will release them on citation and don't search them incident to arrest. So I just don't know how that alternate world would have played out.
And I think the word that the court used that I would hone in on, frankly, is alternative, because it is certainly an alternative argument that we're making. The primary argument being that there was probable cause to search the car because that there was reasonable articulable suspicion to search the car because there was probable cause to arrest for the POCA. And I wanted to make one additional point with respect to that primary argument and, the size of the case and what's reasonable to be found in the case, which is that, I would just note for the court that on December 11th, when Officer Hijazi testified, that the actual case, not just a photo of the case, but the case itself was introduced into evidence and was admitted into evidence without any objection from counsel. And so the court would have had the opportunity to see the case and the size of the case in, the physical case in real life, as would have defense counsel. And there was no, at that point, renewal of the motion to suppress. The trial court did not, ask the parties to come to the bench after having viewed the case. My point being that even upon seeing the case in real life, in person in the courtroom, the trial court, I think it's fair to infer, was comfortable with the ruling that it had made.
The trial court's ruling was also based on a window tint infraction. So, I mean, I think it's safe to say the trial court had its legal analysis a little bit mucked up, and nothing about that case was going to change its analysis under the window tint infraction. So I don't know why you would renew an objection there. But I have one question about your Fourth Amendment argument, just about exactly the type of argument that you're making. There are two different things. There are two different questions we might have. One is, does the Remy Martin bottle give you reasonable articulable suspicion to search the car for things like cups? It strikes me that that's kind of a first question. The second order question is, and if so, what about the particular container here? Is there reason to think this container had evidence of POCA? Do you agree that you need to say that there needs to be reasonable articulable suspicion at both steps to justify this search? Or do you think if there's reasonable articulable suspicion to search the car, then you have free reign to search whatever? Or does it need to be confined by, if this were a search for the Maltese Falcon, which is, about that big and 45 pounds, could they have searched the case if this were, if they had reasonable articulable suspicion to think the Maltese Falcon would be in that car, could they have searched a tiny case? Or do you need reasonable suspicion for the case in addition to the car?
I believe, if I'm remembering the language of, to answer the court's first question, we are arguing that the Remy Martin bottle gave the officers reasonable articulable suspicion to search for cups. So that's the first question. But the second question, again, and this is based on the proffer that was made during the suppression argument, we do think that there was reasonable suspicion in this case to search the case. And if I'm remembering the language of Lewis correctly, the officers, upon developing probable cause for an arrest, must then have reasonable articulable suspicion to search the car for evidence related to that arrest. And so because it's an open container offense here, that's where the size of the case comes into, it becomes a factual issue, which we think the record supports that the case was a reasonable place for the officers to search and that they had reasonable suspicion. But to the court's point about the Maltese Falcon, I'm not frankly sure how big the Falcon is. I don't think it could fit.
It's about a foot high, about 45 pounds.
Certainly. So I think in that situation, based on the court's language in Lewis, it probably would not, they would not be able to open that case.
Okay.
Unless there was some evidence that, I don't know, that the Falcon were locked in a case and the key were inside the case or something like that.
Thank you very much, counsel. We've kept you up at the podium, the virtual podium, for quite some time. So we'll let you sit down now and we'll hear for just a few minutes, Mr. Hart, if you have anything you'd like to say in rebuttal.
Thank you.
Thank you. Mr. Hart, you're muted. Oh, now you are.
Thank you, Your Honor. I'd hoped to spend some time discussing the laboratory commingling issue, but since I did not raise that in my initial presentation, I agree it would be unfair to pop that on the court without the government being able to respond. But I don't want the court to think that we forgot about it because we think it's still an important issue. The second thing I would say,
I do have one question about it, which is, you did say in your initial argument that we wouldn't need to reach that if we agreed with you on the suppression issue. Do you think that's right? If we agreed with you on the suppression issue, it could always be retried. And part of your argument is, well, there was insufficient evidence to convict. And if that's true, then you can't be retried. So, wouldn't we need to? I don't see how we could stop at the Fourth Amendment argument, even if you're right on it. It seems like we would have to address your sufficiency argument independently.
I'm not certain whether you have to, Your Honor, because I'm not certain that that's the case. That would be the case. The last thing I
don't mean to derail you.
If you want to wrap up, Mr. Hart, any final words?
I would, Your Honor. In cases like the one below, where everyone seems to agree on everything for the suppression hearing, those things are written out. Those facts are agreed to, and they're numbered, they're written out, people sign them, and they're filed with the court. The use of the shortcut in this case proves why that's done, and we now suffer the consequences of that shortcut, and that we would submit.
Thank you, Mr. Hart. Thank you, Ms. Kalu. We appreciate your time today, and this case will be submitted, and you may leave the virtual courtroom. Good morning. The second case on our calendar this morning is, sorry, one moment, 20 CV 695. Is it KAYAN or KAYAN?
I believe it's KAYAN, Your Honor.
KAYAN LLC versus AZAD YUNUS et al. Counsel for Mr. KAYAN, if you could introduce yourself for the record and let us know how much time you would like for rebuttal.
Sure. Good morning. May it please the court, Abdullah Hijazi here on behalf of Appellate KAYAN LLC, and I'll be reserving 5 minutes for rebuttal.
Thank you. When you are ready.
Okay. I may please the court. I believe this case has two main parts. The first part is the deciding whether or not intervention would have been proper in this case. And the second is adjudicating the merits of foreclosure purchasers' claim against proceeds or surplus proceeds. The trial court didn't necessarily dispute the entitlement to the claim, but denied intervention. And appellant argued in its brief and below that it should be allowed to intervene as a matter of right under Rule 24A2. Rule 24A2 has been interpreted in a case that we cited repeatedly, the HSBC versus Mendoza case. And that case says in quotes that the rule should be liberally interpreted, end quote. Also says, quotes, that any doubt concerning the propriety of allowing intervention should be resolved in favor of the proposed interveners, because it allows the court to resolve all related disputes in a single action, end quote. In footnote 23 of the Mendoza case, also the court cites the Jones versus Fundufe case that and actually quotes it and says, in light of the purpose of the rule, we agree that it is not enough to deny intervention under Rule 24A2 because applicants may vindicate their interest in some later, albeit more burdensome litigation. And respectfully, we believe that the trial court actually found the exact same thing here, saying that.
Well, I guess, counsel, maybe the key words in there are more burdensome, but let me make sure I understand your position. So take any civil action where person A is trying to recover some money for person B. And so if person A can win in that action, then person B will end up being entitled to a judgment that will give person B some money. And imagine that the unsecured creditors of person B seek to intervene in that action. And they say, look, person B owes us money. And so we have an interest in the possible property that is going to be created by a favorable judgment to person B. And we want to, line up. And if there is such a judgment, we want before the proceeds of the judgment are distributed to person B, if person B wins, we want to, get our place in line. Is it your view that that's an intervention as of right kind of claim, that all unsecured creditors have a right to intervene in any action where the debtor might come into money?
So that's a great question, Your Honor. And what I think is that not every unsecured creditor under the sun could intervene. We are more than just a unsecured creditor here. The foreclosure purchaser basically paid off the foreclosing lender's lien and steps into the shoes of the foreclosing lender. More than that, this is a client that had an equitable lien by equitable conversion from the day of the sale. So this is not just any unsecured creditor. More so, these surplus proceeds were created by money paid by the foreclosure purchaser, Your Honor. So I would argue that, this is the foreclosure purchaser that purchased from the foreclosure sale, created the foreclosure surplus proceeds, was harmed by in the process by the defendant in this case, was harmed. The trustee didn't do anything about it. Then Rule 308D makes it clear that the surplus proceeds that the foreclosure purchaser paid into the court's hands, basically, or the trustee's hands under court order, are basically to be distributed as the court sees fits, which includes equitable liens.
Mr. Hijazi, you just said that you're not any unsecured creditor. You're the buyer at the foreclosure sale, but isn't it true that you bought at a severely discounted price, thereby creating the surplus, right? And you bought at a discounted price because there's uncertainty involved in the purchase, right? There are tenants who are still there, or not tenants, but the owner is still present. There's all sorts of messiness that can happen with a foreclosure sale. It's not uncommon that you have to go to landlord-tenant court to get a judgment of possession, as you did in this case. So it rings sort of hollow, doesn't it, for you to say, well, wait a second, we're in this special group that should get special treatment. You're in a special group because you got a bargain basement price on this property with full knowledge of the risks.
So, Your Honor, I would not say that my client got a bargain basement deal on this property. There was no finding of unconscionable price or that the price was
I'm
somehow
not talking
fair.
unconscionability. I'm just saying you got a good deal because you bought it at a foreclosure sale. But with that kind of transaction comes more risk than, going out with a real estate agent and buying something that's just, on the market on MLS.
So, Your Honor, there are many risks that come with a foreclosure sale, but at the same time, a foreclosure purchaser cannot be held to be liable for every risk under the sun from the day of the sale in paying condo fees, taxes, interest, risk of loss. The house could burn down. And while somebody's in it, the foreclosure defendant could destroy the property and not be allowed to intervene in the foreclosure case and make a claim.
But you have another avenue, right, to protect your interests. Once you've bought the property, right, you can go into landlord-tenant court and get a judgment of possession, which is precisely what happened here, right? On March 6th, 2020, you filed a complaint, or your client did, for a judgment of possession and a request for a protective order, right? To make sure that money was being paid into the court registry for, the equivalent of rent while the prior owner was still in the property. And certainly if the prior owner destroyed the property at that juncture, you could, I'm certain, get some sort of recoupment in landlord-tenant court for those damages, right? But it seems like you decided to then flip and come over to the foreclosure proceeding. What was it, 18 months after that proceeding commenced?
So, Your Honor, this is not a case about possession. This is a case about the damages that my client sustained while the holdover former.
My question is, I know that you don't want it to be a case about possession, but it seems to me like it really is. So you're going to have to persuade me that it isn't, because just telling me that this is a damages case, it sure looks like a landlord-tenant case to me. I mean, this happens all the time in foreclosure sales, where someone remains in the property and the new owner from a foreclosure sale goes into landlord-tenant court and gets a judgment of possession.
So, Your Honor, under LNT Rule 3, other than the payment of traditional rent, you are not allowed to get a money judgment. A protective order doesn't protect my client for the damages that my client was trying to obtain here. For example, it doesn't compensate the foreclosure purchaser for unlawful occupation of the property prior to the closing. It doesn't compensate him for unlawful occupation of the property from the time prior to the entry of the order. And
what about an ejectment? What remedies would have been available to you in ejectment? Because your legal aid suggests that would have been a remedy, and I don't think I recall any response from you in your reply brief on what remedies might have been available to you in an action in ejectment.
Sure. So in an ejectment action, we would have to file a motion for summary judgment pretty quickly. And if the surplus proceeds are gone, then the claim is moot. So we are impaired in the fact, because if we're not allowed to. Is
it implicit in your answer to that the full range of remedies is theoretically available and your concern is more about speed of achieving them?
No, because the ejectment action has basically no control over the surplus proceeds. The surplus proceeds are being distributed under Rule 3 OAD in the foreclosure case, and not in the ejectment action. So I'd be forced to file a motion to consolidate the cases, a motion to stay the case while the ejectment case was moving forward. In fact, I mean, I didn't want to bring this up, but we had another case where we were denied intervention about the same time by the same foreclosure court. It's 14th Street Homes, LLC versus US Bank. And the citation is 2020 CA 004-297B. And in that case, we were forced by the same foreclosure court to file our separate claim in a separate action because we weren't able to get marketable title in that case. And what happened? The case ended up staying the foreclosure case while it's pending, and the foreclosure case has still not moved forward while the separate case is pending. So an ejectment action, a lot of the damage would have been recovered, but we would have no control over the surplus proceeds and no ability to be heard at the distribution of the surplus proceeds without filing a motion for stay, a motion for consolidate, and several other motions to try to make sure that we got at least a word in before the surplus proceeds were
So
distributed.
it's very clear you're hoping by this to essentially secure the settlement, the surplus. If you can't intervene here quickly and effectively secure it, then I understand there's a risk that it will be dissipated or you won't be able to recover it. And the question, I guess, is whether you have a right to secure it, even though you're, an unsecured creditor in some respects. And let me ask you, when I asked you the general question, can any unsecured creditor intervene as of right in a civil action where the debtor might come into money? And your answer, I don't know that your answer was yes or no, clearly, but in any event, your point was, whatever the answer to that broad question is, that's not our situation because your client is differently situated. And I think you identified two respects in which your client is differently situated. One, it created the surplus, and the other, that the damages relate to the foreclosure sale, so they're kind of connected substantively to the foreclosure sale process. Was that right about the two ways in which you were suggesting you're different from the hypothetical kind of run-of-the-mill unsecured creditor?
That's correct, Your Honor. And in addition to that, there is case law basically that we cited from Maryland, and there is also a citation to the HSBC case in which HSBC paid off the loan of I believe is Chase, another lender, and HSBC basically said that they stepped into the shoes and obtained the priority of that lender. So here,
right. Just to figure out which, assuming those are your two main points, whether you think both of them are necessary, whether you think one of them is sufficient, and if so, whether both of them are independently sufficient. So imagine that rather than having a claim that was that arose from damages maybe in the nature of rent type damages for unlawful occupancy after any right to occupy disappeared. Imagine instead the claim happened to be against the same defendant, but it was unrelated substantively. So imagine again, your client has created these proceeds by purchasing this in a foreclosure sale, and you're trying to recover them from the prior owner, but your claim is unrelated and sounds in tort or something like that. So it doesn't kind of have a substantive connection to the foreclosure process. Do you think your client would be entitled to intervention as of right in a case like that because your client created the proceeds in a foreclosure sale where your client is paying money to, again, the tort defendant?
So, Your Honor, if we do step into the shoes of the lender and are the highest secured creditor under that theory, I think yes, because, for example, junior lien holders all the time, or even senior lien holders in these same foreclosure cases, file their claims in the accounting procedure for corporate advances. For example, they say, "Oh, we paid off, we cut the grass, for example, at this property to avoid municipal liens," or we had a flood, for example, had a flood damage and their insurance loss during that time, and that's a tort-based claim, and we had to pay that off, which is a form of equitable subrogation or form of tort damage. And it's corporate.
How would that work though? Does that mean that in distributing the proceeds of the foreclosure sale, the landlord, the foreclosure court would have to adjudicate the tort claim, or how would that work practically?
So, Your Honor, what happens typically in the foreclosure court is the bank's lawyer presents their accounting, and the accounting is then adjudicated by the court and ratified if the court believes that there's substantial evidence and enough evidence to support the accounting. If the court believes that it's not correct, then they'll partially ratify the accounting or reject it, and then the bank has to put up additional evidence or even go through an evidentiary hearing for the court to decide whether or not they should be allowed the full claim that they made under their accounting. The accounting is not just for straight up debt. It also has other corporate expenses.
I mean, I'm not sure though I got a concrete answer to the question I'm posing. So I took your position to be that if the basis for the effort to intervene in this case, everything was the same, but instead of saying I want damages relating to the prior owner overstaying welcome after the foreclosure sale, the claim had been I have a claim against this money because I have an independent, unrelated tort action against the prior owner. And I thought you said that there was entitlement to intervene as of right. And my question was, how does that work practically? Here's the foreclosure court that's got $65,000 and wants to like close this down and be done with it. And is it that the accounting has to be stayed pending and a separate adjudication in some other proceeding, or is your idea that so you can intervene in order to stay pending that other litigation, or is your argument that all of a sudden the foreclosure court becomes a tort court and determines whether your client has a valid tort claim to the proceeds of the foreclosure sale? I'm not quite sure how it's supposed to happen on your theory.
So, Your Honor, if the claim relates to the provisions of the deed of trust and is allowed under the deed of trust.
My hypothetical, it doesn't. And that's why I thought you said it doesn't matter that it doesn't relate.
No, I'm not saying it
Let's
doesn't
make
matter.
let's make this really concrete, right? There's the foreclosure action, there's the purchase of the foreclosed property, and there's the holdover prior owner. And separate and apart, Mr. YUNUS totals a company car for KAYAN LLC, right? And so KAYAN LLC wants recovery for the car being damaged. And they try to go into this accounting saying, we have these damages from our car being totaled by Mr. YUNUS. It hasn't been proven in any court. There hasn't been any civil suit, any complaint filed. Judge McLeese's question is, does now the judge in the foreclosure action now have to essentially have a hearing on the underlying facts of the car being totaled in order to finalize the accounting? Is that your answer?
So my answer is no in this scenario, but that's not what we're claiming here. And the reason I say no is because that tort action is unrelated to the foreclosure action and unrelated to the deed of trust that created the foreclosure under which, and the deed of trust that the foreclosure purchaser paid off, and the deed of trust that secured the property and under which, foreclosure purchaser is here today. And so,
okay, but what about the hypothetical damages that you're talking about to the property? Those seem unrelated to the deed of trust as well, and they are also unproven. Why should the foreclosure judge have to factor that into the accounting? And doesn't there need to be a hearing to figure out what sort of damages the holdover owner has inflicted on the property that you all purchased? I mean, none of this has been established in any court, correct?
Well, Your Honor, they can be established if we were allowed to intervene, and they can be established by affidavit the same way all the lender's damages are validated by affidavit when they submit their accounting under Rule 308.
It seems a little bit more complicated. I mean, if you're saying, look, he ripped out all the fixtures, right? And now, now we have flooding because he ripped out all the sinks and, the toilets, and, he damaged the property, and, maybe Mr. YUNUS has a defense and says, no, I didn't do this, or, goodness knows what the facts are. You think that all of that should be tried in front of the foreclosure court?
If it relates,
if it's never been tried anywhere else, unlike where there's some sort of established debt obligation that's outstanding. This is all subject to, that there's only been allegations, and presumably there's some sort of response saying, no, I'm not responsible for that.
So, Your Honor, the deed of trust in this action allows for the type of damages for use in occupancy damages or rents and profits that similar to what we're claiming here. And again, Our argument is that we step into the shoes of the lender because we paid off the loan. This claim is not the same as some far-fetched claim that has nothing to do with the foreclosure case. And it can be easily done in a motion for summary judgment. It can easily be done for a motion based on affidavit. It can easily be done in a simple evidentiary hearing over 30 minutes. It's a basic claim of, I'm entitled to possession. You didn't give me possession. The fair market rental value is this much. I don't see what's so difficult
But
about.
you're talking about possession. I thought you were saying in addition to possession, which it seems like you really could deal with in landlord-tenant court, right? By getting a protective order and saying, you know, this is the amount of money that he has to pay while he continues to possess the property against our wishes. I thought you were talking about actual damage, physical damage to the property. You know, he graffitis the walls, allegedly, and, you know, that's your allegation. It seems like a factual claim that would have to be tried, and there would have to be factual findings, and witnesses would have to come in, and exhibits would have to be displayed to the court to say, yes, this in fact happened. He was responsible. And that's what you want the foreclosure court to do.
So here, Your Honor, our claim is purely based on the fair market rental value and unlawful possession after the sale. We didn't have those.
Oh, so you're not making a physical property. I thought, okay, so okay. So this is just about his holdover tenancy.
Correct, Your Honor. And
Okay. Why is that can't be addressed in landlord-tenant court again?
Because again, Your Honor, the landlord-tenant court under Rule 3 is not allowed to enter money judgments except for rent. And the Nicholas case basically that we cited says that this is not your traditional rent. This is basically a claim for an accounting for the damages that the property owner has sustained for unlawful, basically holding over and the fair market rental value. How would the landlord-tenant court even know how to set the rent when there is no lease between the former owner and KAYAN LLC? So there is a huge jurisdictional issue. Other than that, practically, a protective order here was requested, and 2 years and 1 month later, my client got possession and didn't get anything out of the protective order and didn't even get a protective order. So that's prima facie evidence that the protective order is not a way to resolve this case. In fact, the Maryland Court of Appeals case that we cited, the legacy case, found exactly the opposite. It found that you should not make a foreclosure borrower have to face multiple cases relating to the foreclosure property for a claim against surplus proceeds, and they said that was akin to vexatious litigation tactics and cases that could result in conflicting orders. So I don't understand. I mean, I understand why legal aid doesn't like the claim against surplus proceeds on the merits, but I don't understand why they don't want it to be heard in the foreclosure case and would rather subject the foreclosed homeowner to a second case, this additional possible discovery, additional motions, and have the risk of having conflicting orders as to the surplus proceeds from two different cases. So
there is no question. Legacy funding doesn't even use the word intervention or intervene at any point. It's not an intervention case, right?
So the legacy case was about whether or not a foreclosure purchaser should be able to file a claim against surplus proceeds or a claim for a money judgment against a foreclosed homeowner in the district court, basically, which is akin to the Superior Court L&T branch here in DC. So the court said no, because that could easily result in conflicting orders. That's vexatious and the reason the foreclosure purchaser probably wanted to do it in legacy was because just like in the landlord and tenant court in the District of Columbia, the landlord and tenant court in Maryland provides for summary ejectment proceedings, summary possession actions, so they're faster. The court said no, that's not the proper way to do it because the district court doesn't have the surplus proceeds. This is not the foreclosure case. The merits of the foreclosure case isn't before the district court, and even if the court did enter a money judgment, then it may conflict with the order distributing the surplus proceeds in the foreclosure case. So in fact, I mean, the Maryland Court of Appeals, is persuasive authority under Napoleon versus Hart and speaks to what legal aid should be trying to protect here.
Did you have filed an actual lien instead of against the settlement proceeds rather than asserting an equitable lien?
So again, the lien that we assert under, the actual lien that we assert entitlement under is the lien that's being foreclosed in the foreclosure action, the recorded deed of trust. Other than that, the only way to assert an actual lien beyond that would be to get a new judgment lien. And that's what legal aid argues that we should have had to do. While at the same time, we argue that that will result in conflicting orders, possibly will result in putting a foreclosure defendant, subjecting them to additional litigation.
Can I make sure? Can you explain the conflicting orders line of thought? I know it was in the Maryland referred to it in the legacy case, but if the court were to conclude here that the foreclosure is just going to go its merry way without getting into all of this, then the foreclosure, the proceeds will be distributed independent of that, this set of claims, and your client will be required to establish them in some other place, and your client will have to try to recover them. If your client gets a judgment, your client will have to convert that judgment into recovery in the same way that other folks do. Where are the conflicting orders?
So let's say, Your Honor, we get an ejectment action, we filed an ejectment action, and we do get a judgment. And again, we're arguing here that we have first lien priority against other junior lien holders because we paid off the highest priority lien in this case here, if there were junior lien holders. So if the ejectment action results in a judgment, and then that judgment does not get rolled into the surplus case, and the surplus is distributed to other junior lien holders, then that's a conflicting order. If it gets distributed, for example, to the defendant, even though we have a judgment against the actual surplus proceeds, where the judge in the ejectment action not only enters a money judgment for us, but enters an order saying that we should be able to get the surplus proceeds from the court registry, then that is a conflicting order. You have one order in the ejectment action says that we get the money from the court registry, and another order in the foreclosure case that says that it should go to someone else.
Maybe.
I guess I'm just not understanding because, right, at the end of the day, if the money goes back, if the surplus proceeds go back to Mr. YUNUS, it seems like then he could be ordered to pay them into the court registry, or in an ejectment action, he could be ordered to pay them directly to you. So it's just sort of how you get the money. The money is not necessarily lost, but whether or not you get to get it in this action, which you are seeking to intervene in a year and a half after it commences, while you already have a pending action in landlord-tenant court. So your argument about duplicative proceedings seems a little odd because you're the one who started the landlord-tenant action. I guess I'm just not understanding sort of the core of your injustice argument of we're not going to get our money. You can get your money, but maybe just not in this venue.
So
what am I missing?
So first of all, the landlord-tenant action is not for money; it's for possession, and Rule 3 does not allow us to get a money judgment in landlord-tenant court. The claim against proceeds is.
But you would get a protective order that would protect your interest in the property and your entitlement to the equivalent of rent from someone who continues to remain in that property. And my understanding is for a foreclosed homeowner, that's going to be essentially the amount of the mortgage, right? I mean, you ask how the trial court could assess what the value is of that. I'll ask legal aid the same question, but my sense is that they do this on a regular basis. And you can litigate what the amount of the protective order should be.
So the protective order in this case, after 2 years, wasn't entered, was not given to my client, and my client was not protected by the protective order in any way, which is why we're saying his rights were going to be impaired if he wasn't allowed to intervene.
Do we have the order denying what the protective order? Do we know why it was denied in this case?
It was just never granted because
after you asked for it on March 6th, 2020, did you renew your request? Did you remind the court that you had a pending request? Like, do we have any of this information as to why it was just never granted?
So, Your Honor, even if it was granted, it doesn't protect my client against the time prior to the entry of the order, or prior to the sale, or prior to the the filing of the landlord-tenant action. And it doesn't protect my client if it's just breached. If it's breached, then there's no money to be had, and it's not a money judgment. A protective order is akin to injunctive relief that says either pay.
I understand that line of thought, and I guess I mean, that's life as an unsecured creditor is you're not fully protected until you can get yourself some sort of security. So that's kind of intrinsic. And so if your argument to prevail, I think it has to be more than just your client would be better off if your client could get in the front of the line here. It has to be more conceptually the idea that you stand, and the way you were putting it, and this is in your brief too, I know, is that you stand in the shoes of the lender because you paid off the senior lien. And is that a stand in the shoes is a metaphor, of course. So is it your position that if at a foreclosure sale, the property being foreclosed is subject to a senior lien, typically, you know, a mortgage from a bank, and the foreclosure purchaser, you know, pays more than that amount, and therefore, when the funds are distributed, most of those funds, or a lot of those funds, will go to the senior lien holder? Is it your view that in a setting like that, the foreclosure purchaser kind of gets all of the rights and benefits that the senior lien holder had? Or what's the basis for this kind of metaphor of stepping into shoes, and how extensive is the shoe stepping? Is it complete? So you get, like, you know, both pairs of sneakers and all the laces and everything, or how does the metaphor work?
I believe you're. I would argue that it's limited to the four corners of the deed of trust. So what in the note, whatever contractual provisions were there, or provisions that caused the foreclosure to go forward, or the provisions that the foreclosure purchaser.
So if the deed of trust says that the bank has various remedies, you know, accelerating, I mean, you know, there are millions of provisions in there, and you're saying that a foreclosure purchaser has all of those remedies automatically, when simply in virtue of paying the foreclosure, you know, being the successful bidder at the foreclosure sale, and thus paying some or all of the senior, I mean, it wouldn't necessarily be all. If there's no surplus, it only might be some of the senior lien. Is that, that's your, like, whatever remedies are available to the bank are, you know, are in the deed of trust are available to your client?
So to the extent that they're applicable and equitable, Your Honor, because at the end of the day, the whole stepping into the shoes theory is an equitable theory. For example, if there are provisions that are applicable and equitable, then yes, the foreclosure purchaser should be able to take advantage of them and request relief under them, because at the end of the day, but for the foreclosure purchaser, the surplus proceeds would not exist, the lien would not have been paid off, and the foreclosure sale would not have gotten to the accounting phase, and the phase that we're here today. So, I mean, the foreclosure purchaser can't be held liable for all the risks that the deed of trust the lender holds pre-foreclosure sale, plus more risks that the homeowner might hold, and then not be given any rights or remedies that the lender would be able to take advantage of after the sale. It's just not constitutional in any way to hold that. We cited the Ursiola case that even finds that municipal liens or taxes are assessed against the foreclosure purchaser from the day after the sale. Those are risks that are even beyond what lenders would have to hold. Those are risks that lenders only have to pay to protect their lien interest, but are not liable for personally. But the Supreme Court has held that a foreclosure purchaser is liable for those risks. So this is not, even if the court is not convinced that the stepping into the shoes of the purchaser theory is applicable here, at the end of the day, this is somebody with not just equitable title from the sale, but complete legal title to the property after closing and after obtaining the deed to the property. So at the very least, the claim should have been allowed, since we filed it after the closing occurred.
Counsel, you are well over time, and that is largely our fault. So I'm going to let you step back from the microphone. If you could mute your microphone at this point, and we will hear from Mr. Hill.
Good morning, Your Honors. May it please the court. My name is Zack Hill, I'm an attorney with the Legal Aid Society of DC. Legal Aid filed an amicus brief in this matter, respectfully requesting that the court affirm the trial court's order. Your Honors, in a way to address some of your questions and also to illustrate why intervention in this case was not appropriate under Rule 24A2, it may be helpful to compare what happened here to what would happen in a private real estate sale. Let's say for a moment that there had not been a foreclosure and that Mr. Yunus on his own had decided to sell his property to KAYAN LLC. Using my own experience buying a home to guide me, what would have happened is there would have been a settlement. Money would have been wired to Mr. Yunus at that settlement. He would have given his keys to KAYAN LLC. An escrow agent or a title agent would have been responsible for making sure that the money that KAYAN was spending went to extinguish any liens, any recorded judgments at the time of settlement. And the two parties would go their separate ways. If KAYAN discovered a week later that Mr. Yunus had given them some other key, or if Mr. Yunus had decided, actually, I want to live in my former basement for the rest of my days, good luck trying to evict me, it wouldn't matter if KAYAN's claim against him was clear as day. From KAYAN's perspective, the money it had spent on that house would be gone. It would be in Mr. Yunus's possession, and KAYAN would have the same remedies that your honors were talking about, the same remedies available to any home buyer, any purchaser, to sue Mr. Yunus, to bring an ejectment action against him, to bring a landlord-tenant action against him, and to get their money that way. That is not only the equitable outcome here, it's the outcome that's required by Rule 24A2, which is the rule that KAYAN is seeking to intervene under. Rule 24A2 requires an intervener to claim, quote, an interest relating to the subject of the action. KAYAN's claimed interest is use and occupancy damages that accrue after settlement of the sale. The subject of the foreclosure action is never going to be use and occupancy damages for charges that accrue after settlement. The account ratification, which is the stage at which KAYAN tried to intervene, is governed, as opposing counsel has pointed out, by Rule 308D. And it's also governed by the judgment order issued on the merits in the underlying foreclosure case. And I'm happy to get more specific about what each of those say, but the common theme between them is they say that foreclosure proceeds, to the extent that surplus proceeds exist, go to claims that have been established at the time of settlement. And in fact, go to liens, go to recorded judgments. And a recorded judgment can certainly be completely unrelated to the property. As long as it's recorded at the time of settlement, proceeds from the sale will go to satisfy that debt. That is the subject of the account ratification stage of a foreclosure case. The subject is not determining who has a claim against the foreclosed homeowner after settlement, and it's not distributing money to unsecured creditors. It's frankly mostly a ministerial step where the court is, as counsel has pointed out, reviewing the trustee's accounting, and it gives junior lien holders an opportunity, if for whatever reason they've been excluded from the accounting, to file a motion to intervene, and a motion from a junior lien holder at that stage should be appropriately granted, because that relates to the subject of the action, which is distributing sale proceeds to parties who have a recorded lien or judgment at the time of settlement.
Can I ask you a question about your analogy to a private sale? With respect to is the purchaser in a private sale situated identically to the purchaser in a foreclosure sale with respect to tax and other obligations as in terms of when they start up, or would the purchaser in a private sale be differently situated?
Yeah, I believe they would be situated the same, and that in fact, I believe that purchasers at settlement pay the next quarter of taxes, to property taxes, to the DC government. Purchasers are responsible for taxes, for insurance, for mortgage payments starting at settlement, and that's regardless of whether they get possession. There's a risk in any transaction where a party is buying a home that the home will be in a different condition than what they thought, or that they'll have to fight to get possession. If anything, those risks are spelled out more clearly in a foreclosure sale than in a private sale, but they are absolutely present, and the responsibilities of a purchaser will be the same. as they would be in a non-judicial foreclosure, where I do think the outcome would be the same. If KAYAN had purchased this home in a non-judicial foreclosure, proceeds would be distributed to parties who had liens at the time of settlement. And if KAYAN did not get possession, even if KAYAN's claims against Mr. YUNUS were crystal clear, no one could contest that KAYAN has clear claims, KAYAN would have to bring a separate action against Mr. YUNUS. The money it had spent on the property from KAYAN's perspective would be gone.
So
I just want to make sure, oh, I'm sorry, go ahead.
It's okay. Just a quick question on your reading of Rule 24. So I had thought primarily your view was, and I thought the trial court's view primarily was, that as a practical matter, not permitting intervention here is not going to impede KAYAN's ability to proceed in a different proceeding, maybe a cause of ejectment. But what I think I heard you say is that this doesn't even meet the sort of first clause of 24A2, that they're not claiming an interest relating to the property or transaction. That seems like a pretty narrow reading of that phrase. But is that your principal position? This doesn't even relate to the property or transaction issue in the foreclosure sale?
Yes, Your Honor, and I do anticipate making both arguments, both the impairment argument, but yes, I am arguing that their interest does not relate to the subject of the foreclosure action. The subject as
third argument too, which is that being the potential interest of an unsecured creditor that, with a claim that hasn't been adjudicated or reduced to a lien or something isn't a legally cognizable interest. Am I misrecollecting that you were making that argument as well? I know some cases seem to have taken that view in some settings. Were you making that third argument as well, or am I attributing to you more than what you were arguing?
Your Honor, I'm hoping I understood your question, but our position is that a party without a recorded lien or judgment at the time of settlement does not have an interest related to the foreclosure surplus.
Well, I guess the point I'm trying to make is, one is whether an unsecured claim is just not an interest of the requisite kind. It's not legally cognizable. And then there's another thing, which is whether the claim has the requisite relationship, the interest has the requisite relationship. And that, I thought you were making a somewhat different point than, I mean, even if it was a, again, I thought you were making a separate point about this can't be related to because it arises after. So that seemed different from the secured, unsecured point. So I was thinking maybe, I hadn't realized there were two different points here. I was thinking maybe you are making two different points, but I'm not sure. So I just want to make sure whether you're making two somewhat distinct points or not. I'm unsure.
You're right, Your Honor. I think I was sort of melding two distinct points. The first is that the only parties that are going to have a Rule 24 interest in surplus proceeds or in any sale proceeds, regardless of the context, are going to be parties with a secured debt recorded at the time of settlement. The second point I think was perhaps indirectly making was that KAYAN, like any foreclosure purchaser, by definition is never going to meet that standard because their interest in any use and occupancy damages is only going to accrue from the point in time that they get legal title. And I know that goes into the second argument of that, their second issue before.
And just to distinguish between the two, imagine that KAYAN was making a claim that before closing, the prior owner had done physical damage to the property. That claim at least wouldn't be arising after the transaction, like overstaying your tenancy would. So it wouldn't have one of the 2 points, but if it was an unsecured claim, your view might be that it's just not the right kind of interest. Am I, again, picking up the difference between the two lines of thought? Or?
Correct, Your Honor. If their claim was related to damage, that would still not meet this standard because they would not have a recorded judgment at the time of settlement, which would also be the case in a private sale. If KAYAN did a detailed inspection and the home was in great condition and they returned from settlement and saw Mr. YUNUS had trashed the place, the money they spent would still be gone and they would need to bring an action against Mr. YUNUS. That should be the outcome here. No indication that Mr. YUNUS trashed his former home. And that is the outcome, I think, required by a reading of Rule 24. And Your Honor is correct. Rule 24 only allows a narrow group of parties to intervene at this stage of a foreclosure process. It's the final step in the foreclosure process. Account ratification is the final step of the process. It occurs when the merits have been fully adjudicated. Procedurally, the case is 95% done. It is a ministerial step where the court is finishing up the last remaining pieces, and it's not the step where collateral matters, the issues that have not been fully adjudicated, or in this case have not been adjudicated at all, should be addressed under Rule 24. KAYAN's argument.
That is it fair to say that this point in part is a local geography point about accounting and foreclosure sales as opposed to a general feature of Rule 24A2? I mean, would you agree that a lot of times folks who are entitled to intervene under 24A2 don't already have a lien or final, judgment establishing their claim? That's not a general requirement of intervention under Rule 24A2, or do you think it is?
Your Honor, I do think it's tied closely to the particulars of DC foreclosure. I think it's helpful to look at the text of Rule 308D, which is what governs this particular stage of the foreclosure process, which states that promptly after the settlement of a private or public sale made under this rule, a full and detailed account shall be filed. This is mirrored in Judge Cordero's order on the underlying merits of the foreclosure case, which is not part of the appendix, but the court can certainly look at the order because it's part of the record of the case, where Judge Cordero ordered that the notice of accounting be filed and sent to the borrower and junior lien holders within 60 days of the settlement. So it's clear from the rules that govern this stage of the foreclosure case what the surplus is meant for and what parties have an interest in the surplus that they can assert and try to intervene under Rule 24. KAYAN's position seems to be that it would be much easier for them if they could just automatically get money from the court. And from their perspective, that's certainly right. It would be a lot easier if they didn't have to bring a separate claim, just as it would be a lot easier for any of Mr. Yunus's creditors, if they exist, to skip bringing a collections case, to skip the sort of procedural steps involved in that, and just automatically get money from the foreclosure trustees. But that's not how court works. The court doesn't freeze a defendant's money in place just because someone might have an interest. KAYAN's interest.
Your opponent's argument is maybe that's so, but the equities favor permitting that here in a way that's different from the run-of-the-mill creditor. And then that gets back into the idea that the surplus was created and that the conduct here is overstaying. So the idea is it seems kind of unfair for KAYAN to pay a bunch of money to get to buy a place, to have the prior owner unlawfully stay there without paying any rent, and have the prior owner be able to just take the proceeds and make off with them, and leaving KAYAN to later difficult separate litigation remedies that will be, create risks of further burdens of delay and cost, and risks that the money will not be retrievable. So that's the gist of their equitable point is that just seems unfair. And so why shouldn't the system permit at least the person who is creating the surplus and who is entitled to have have possession be able to kind of jump in and say, look, if you're not going to vacate, you're not going to get these proceeds that are premised on the idea that you are going to vacate in favor of the person who's generating the proceeds. That's I think the equitable gist of the argument. And what's your response to the idea that it seems there's a certain fairness to permitting that?
Your Honor, in my view, the equitable outcome is to treat KAYAN the same as any other purchaser, any other home purchaser. And I'm certainly not arguing that they should be impaired or face challenges that a private home purchaser doesn't face. And I'm not arguing that this court should afford any special protections to Mr. Yunus. I'm arguing that KAYAN should be treated as any other home buyer, and Mr. Yunus should be treated as any other home seller, where even in a private sale, if KAYAN was aggrieved, the money it spent, the money it wired would be gone, and KAYAN would need to bring a claim against Mr. Yunus. and it would be free to seek a money judgment against him, to garnish his wages, to attach his bank account, to do any number of things that creditors in DC can do. It's just not entitled to intervene under Rule 24 in a subject that's not related to its action. And Your Honors, I see that I'm running out of time. I did want to briefly talk about the second issue in this case, which is at what point in time KAYAN would be entitled to use and occupancy damages. Although I should note that, for the sake of argument, I'm certainly happy to argue that KAYAN would be entitled to some amount of money. That issue has never been proven. And KAYAN has never received a judgment from any judge saying you're entitled to X amount of money. It's certainly possible that given the condition of a property, KAYAN could be entitled to $0 in rent. But for the sake of argument, happy to assume that KAYAN would be entitled to some amount of money. That amount would start to accrue at the date it received legal title. And I should say, this is also an issue the court does not need to address if it affirms the trial court's ruling on intervention. Finding that any damages KAYAN is entitled to would accrue at the date that it obtains legal title is consistent not only with DC code, it's code section 45522. It's also consistent with a clarification unanimously passed by City Council in March, clarifying that purchasers at foreclosure sales are not entitled to possession or use and occupancy damages until they obtain legal title. And it's also consistent with this court's own ruling in the 2014 case, Hernandez v. Banks, where the court was very explicit that a purchaser is not entitled to legal title or not entitled to damages until it obtains legal title.
You read Hernandez versus Banks as a flat rule or a case-specific conclusion that in the circumstances there, it wouldn't have been equitable to permit such damages at that time?
Looking at the text in Hernandez v. Banks, Your Honor, it does seem to be stating a flat rule. There's no, at least in my reading of the case, there's no couching that holding in the facts of the case. It's a fairly blunt description that a purchaser is entitled to damages at the time they gain legal title. Which is also
assume that the foreclosure sale goes forward and your client was obliged to vacate on a particular date, and assume for a moment that there's no dispute about the condition, and so if the matter were adjudicated, your client would be held to have acted wrongfully and be responsible for an amount that would be probably comparable to what the pre-existing rent would be. Why does it make sense in adjusting the rights of the parties? I mean, I understand that your client would be treated as a holdover tenant. There'd have to be a notice to quit, and so there'd be a process before your client could be removed, despite your client's holdover status in this hypothetical. But why should, in settings like that, clients be permitted, holdover tenants be permitted to essentially live rent-free for a while after the period of lawful possession is over? Could you just explain why that is logical or fair?
I mean, Your Honor, they wouldn't be allowed to in the sense that they would be living there illegally, and they would suffer the consequences of, in this hypothetical, clearly losing a landlord-tenant case, potentially having a protective order against them, potentially having a money judgment against them. Those are the remedies that are always available to owners of property where there's an unlawful tenant. That there's no other remedy in DC other than that, and the court should not be.
My question is just why is it, assuming that the logical consequence of that is that for a period of 2 months between the time of the foreclosure sale to the time or the obtaining of equitable title pursuant to the foreclosure sale and the time of obtaining legal title, imagine that a client with no a prior owner with no justification just stays on for those 2 months. And you're saying that the right answer is that the new owner should be entitled to no damages, and the holdover tenant should have no legal responsibility to pay any money relating to the occupancy for that 2-month period. I understand there are other remedies, but I'm not quite sure why it makes sense that there would be no remedy in damages for that period. It seems like in that hypothetical, the holdover tenant has been given a benefit that the holdover tenant was not legally entitled to. The new purchaser suffered a legal detriment, and you would think that it would be more natural to have there be a remedy in damages so that the person who acted unlawfully and benefited therefrom would be required to make whole the person who suffered a legal detriment. Could you just explain to me why it makes sense to not permit that remedy?
And Your Honor, I apologize. I just want to make sure I understand the question. Are you asking specifically about the period between when a purchaser has equitable title and when it gains legal title?
Yes.
Okay, yes. Your Honor, that is part of the risk in a purchaser or a foreclosure purchaser such as KAYAN buying a property at auction, that there is going to be a gap in time between when it has equitable title and when it has legal title. That, I think provides a strong incentive for purchasers to convert their equitable title to legal title by paying the purchase price. Legal aid is aware of any number of cases where purchasers don't do that and where all the parties exist in this sort of in-between state where property rights are split up. That is an explicit part of the risk. It's why, as Your Honors have pointed, or perhaps why, as Your Honors have pointed out, properties at foreclosure sales typically go for well below market value. There are risks that are inherently baked into this process that purchasers knowingly accept so that they can get property at potentially below market value. And Your Honors, if I can just make one quick final point addressing why legal aid is here as amicus, and Mr. YUNUS has obviously never participated in these cases, so I can't speak to him. Legal aid has advised and represented a number of clients who unfortunately have lost their homes to foreclosure and who rely on whatever surplus remains from that to meet their basic needs, to buy food, to buy clothing, to provide for their children. Our interest is in protecting the surplus, and it's an interest that City Council shares, as evidenced by its unanimous vote in March to protect the rights of foreclosed homeowners. What we're asking is not that this court create additional protections for foreclosed homeowners, and we're not asking that the court impair foreclosure purchasers. We're simply asking that the court not allow a party with no interest related to the subject of a foreclosure action to intervene in this case.
Thank you, Mr. Hill. And now, Mr. Hijazi, we'll hear from you a few minutes in rebuttal.
So I'm going to go back to the point that in footnote 23 of the Mendoza case, the court found that it is not enough to deny intervention under Rule 24A2 because applicants may vindicate their interest in some later, albeit more burdensome litigation. And that's exactly the gist of this case. And for the court to ignore that, and the trial court did ignore that, I mean, that's improper error of law here. And this is not, and even if the standard was abuse of discretion, then that is an abuse of discretion. And in fact, every other option that we had would have impaired our rights or presented a strong risk of impairing our rights, which is exactly what happened. The protective order didn't help. And even if there was an ejectment action, the ejectment action wouldn't have resulted in the judgment that would have been in favor or met the standards that legal aid is trying to hold us to, which is a lien that existed prior to the sale.
And does that, I mean, I'm just, what makes an ejectment action more burdensome in your view? I mean, it sounds like what you're saying is, well, it's more burdensome if we're going to have a harder time to collect, a harder time collecting our money, which doesn't strike me as anything about the proceeding being more burdensome. It strikes me as, you know, a question of, well, I guess my question is just, is that what you think the standard is for whether or not another proceeding is more burdensome? If you have a harder time collecting at the end of it, then I think everybody gets to intervene as a matter of right. Any creditor would get to intervene as a matter of right here, because it would certainly be easier to jump the line and grab this money while it's sitting in a surplus. So what makes an ejectment action more burdensome? So
we already have a case where we bought the foreclosure property from. So KAYAN bought the foreclosure property. The foreclosure defendant is already before the court, and the trustees already before the court, and the court already has the surplus proceeds. opening a new case relating to a claim against surplus proceeds in a case where the court may not be aware what's going on in the other foreclosure case is more burdensome, because it will force us to file motions to consolidate, possible motions to stay, a motion for summary judgment before the surplus proceeds are distributed, and then for lack of a better description, enroll that judgment into the foreclosure case before the surplus is distributed. So it's not just that the collection is harder, which is a large part of it. It's also because that there are many other steps that are going to cause collateral attacks against the foreclosure surplus proceeds and the foreclosure defendant that will be necessary just to have the merits of a very simple claim adjudicated in front of a court that's already dealing with the same subject.
Can I ask you, one of your opponent's themes was what should happen here is the same thing that should happen in a private sale. And the premise of that is that a private sale, someone in your client's situation would not have a remedy other than filing a separate action. Do you, I'm interested in your response to that, and I guess there are two halves. One, do you agree with what he says the rights would be in a private sale? And two, if you do you think that there's a reason why your client should have a better arsenal of remedies because this is a foreclosure action?
So yes, Your Honor, this is not akin to a private sale, because in a private sale, KAYAN LLC would not have had to pay for all the taxes, condominium association fees, the interest on the unpaid purchase price of the mortgage, and would not have had to bear the risk of loss between the day of the sale, the day of the contract signing, basically.
Nobody's making your client do any of that. Your client chose to do it because your client thinks even though you have to do all that, it's in your client's financial interest. So I'm not sure. I mean, I take your point that it's different in that way, and it would be quite different if someone was making your client engage in this transaction. But if your client is a successful bidder and thinks on balance, I'd like to buy this, notwithstanding that they're, for whatever price that may well factor in all of that, I'm not quite sure why that is a strong argument for treating your client differently from what would happen in a private sale. So what am I missing?
Your Honor, it's not that my client chose to do that contractually. It's beyond that. The Ursiola case that we cited is a case where the government held a foreclosure purchaser responsible for municipal liens from the day of the sale, regardless of what the terms of the sale said. So it's a more onerous sale. And at the same time, my client, again, we made the equitable stepping into the shoes of the secured lender argument. And to the extent that our equitable lien from being the foreclosure purchaser, the successful purchaser at the day of sale needs to be recorded, then it is recorded in a report of sale that's a public document in the foreclosure sale reported by the trustee and before any of the surplus is paid into the court registry. I mean, there are many avenues here explaining why a foreclosure purchaser or legitimizing why a foreclosure purchaser should have equal access to file claims and intervene in a foreclosure case when they are the successful purchaser from the foreclosure sale contract. They paid the mortgage that was in default and was the underlying mortgage in the foreclosure case. They were harmed by the same foreclosure defendant due to something that's within the scope of the deed of trust and the property that's the subject of the foreclosure sale. This is not a traditional sale where Mr. YUNUS would have delivered possession at the time of the closing and given us the keys in return for money, and this would not have happened in a traditional sale. And even if it did happen in an additional sale, and there happened to be funds in escrow, I can guarantee you most purchasers would make claims against those escrow funds before they were distributed by the escrow agent, similar to what is happening here. To the extent that the court even gets
very
to
quickly,
the
Mr.
Allen
Hijazi, because we're well over time. So if you could just wrap it up now.
Yeah, to the extent that the Allen Amendment is even something that the court can consider here, it is not law yet, and it is not retroactive, a point that's accepted by legal aid. And Hernandez versus Banks was not a is not akin to this, the facts of this case, because this is the former owner that's holding over the property and not a tenant of the former owner.
Thank you very much. We appreciate both your arguments here today, Mr. Hijazi, for your client, obviously, and legal aid as amicus. We recognize that Mr. Yunus is not your client, even though I think we may have referred to him as such throughout the argument. So thank you both. The case will be submitted and you all may leave the virtual courtroom. Thank you.
Thank you. Have a good day.
Good morning. We are here. Well, let's make sure that we are all here.
I apologize. I had to click some buttons on a laptop.
No worries at all. We are here for the third case of the morning. Sorry, we're a little bit late, later than anticipated. The third case is 20 CV 635, Foster House Tenants Association versus New Bethel Baptist Church Housing Corporation, Inc. et al. So we have Mr. Konopka. Am I pronouncing it correctly?
That's correct, Your Honor.
If you could introduce yourself for the record and let us know how much time you would like for rebuttal. And I guess Amiki is here and I would like to hear how you all intend to split your time.
Absolutely. Thank you, Judge Easterly. And may it please the court, I'm Eric Konopka for Foster House Tenants Association. We'll be sharing 5 minutes of our time with Amiki, and I'd like to reserve 2 minutes for rebuttal, if I may. Your Honors, this case is the latest in a long line of attempts by landlords to deprive tenants of their rights under the Tenant Opportunity to Purchase Act. New Bethel entered into a 104-year ground lease that gives Evergreen the right not only to develop the vacant portion of the property at issue, but also to assume control over and indeed knock down the existing Foster House rental building. This is exactly the sort of transaction that triggers tenants' TOPA rights. Today, I'd like to emphasize really 2 points. First, the plain terms of the ground lease show that it meets the definition of a sale as a matter of law. In the words of section 42-3404.02b, New Bethel executed an agreement, the ground lease, under which it agreed to, among other things, relinquish possession of Foster House and transfer responsibility for taxes and insurance to Evergreen. Second, the putative offer of sale that New Bethel issued 15 months after the ground lease and 6 months after we filed suit did not and could not dispose of this case. Holding otherwise would invite serious gamesmanship and would gut TOPA's protections for tenants. I'd like to turn first to the terms of the ground lease and the terms of TOPA. As I mentioned, section 42-3404.02b defines a sale as including, but not being limited to, any agreement pursuant to which the owner of the housing accommodation agrees to some, but not all, of 6 factors. It's a very broad definition, and as a Superior Court recognized, the ground lease at issue here contains several of the factors enumerated in the statute, including relinquishment of possession and transfer of responsibility for taxes and insurance. It also gives Evergreen the option to add the Foster House building to the lease, which is or is at least similar to a purchase option under the statute. The defendant's only counter argument that they've raised is that the addition of the existing Foster House building is sort of contingent, that it didn't transfer over on the date that the ground lease was executed. And the statute just doesn't say that. The statute focuses on the execution of the agreement and what the owner of the housing accommodation agreed to as of that date. It doesn't say that.
Sure, you think in subsection B of the operative provision, I'm not going to say all the decimals here, hopefully we'll be oriented on that. When it says a sale includes the execution of any agreement, you think the word execution means both parties have signed it so that it becomes a contract that has been formed? Is that how you understand the term?
That's how I understand the term execution. And again, I think that you pair that with the term agree to, right? That what the statute is really focusing on is the execution of an agreement under which the owner agrees to these certain things.
Yeah, help me with one. I mean, that seems like a natural meaning of the word execution, although I'm not sure it's the only possible one. I find it confusing in conjunction with subsection A, which says before selling the sale, paraphrasing here, but before the sale, let me pull back up so my paraphrase will be a little bit better. Hold on one moment.
Before an owner of a housing accommodation
may-
may sell.
then the owner has to give the tenant an opportunity to purchase.
That's correct.
So do you think that seems to mean if execute means sign if sale includes executing an agreement that does certain things, then and if you have to give a tenant opportunity to purchase before you sell, that seems like you have to give a tenant opportunity to purchase before you sign the agreement, which seems puzzling in light of some other TOPA provisions that seem to contemplate that one of the standard ways to make a third party, to make an offer of sale to the tenants is to say, look, we have a third party contract, here it is, it's been signed, we'll give you the same, opportunity. So can you help me just fit together those pieces, because I find them confusing?
Sure. I think probably part of the confusion just has to do with kind of the way that the statute has grown over time. Obviously, initially a sale was just a transfer of absolute title, and the council has expanded it repeatedly over the years, as counsel for legal aid will certainly discuss. The way that we sort of understand is, probably 90%. I don't have any specific figures, but the vast majority of cases under TOPA kind of arise in the traditional fee simple sale process, and in that you generally have a two-step transaction. You sort of sign an agreement that recognizes tenants' TOPA rights, and then at some point thereafter, a few months later, you close on the agreement. And during those 2 dates, it's customary for the owner to then give an offer of sale, and as your honor is mentioning, sort of use the third-party sale agreement or third-party purchase agreement as the benchmark for the offer of sale. I think the difference in a case like this is that we have a little bit of kind of an analogous situation in that the defendants entered into a term sheet as early as May of 2018. They executed the ground lease in November of 2018. And so there was a little bit of a window in which they could have used the terms of the term sheet as a sort of the equivalent of a third-party transaction. But I think the analogy is a little bit different because there is no second step. Once the agreement is signed, in this case, the terms are closed. New Bethel has agreed to everything that it agreed to under the contract, and so there is no second step. And so it just makes sense that the offer of sale would have to be issued before that agreement is signed. That being said, I think that there is some case law, the fourth grade case, for example, recognizing that, look, if they had signed the ground lease on November 30th of 2018 and then issued us an offer of sale on December 1st of 2018, we'd have a very different case. You might say in that situation that, we got everything that we could have possibly asked for, and particularly if the terms of the transaction matched what the third-party sale agreement gave, then we'd really probably have no cause for concern. And I think that would be, a situation in which there wouldn't be any real harm to the tenant association. We find ourselves in this position. Sorry.
Just to go back to Judge McLeese's question, I mean, what you posit certainly makes logical sense, but it's not really in the statute. Would you agree? I mean, there's just sort of the bare language of before an owner of a housing accommodation may sell. So this sort of your interpretation of that there's no other part of the statute that speaks to how this should work, particularly in a lease situation as opposed to a sale situation. Is that correct? Or is there other guidance that you can give us in the statutory language?
There is very little guidance, both I think in the statute and in precedent for these types of transactions. I think the only statutory provision I'm aware of that really bears on this and does draw some analogy to the traditional sale context is that there is a provision in TOPA that sort of allows an owner, if they've entered into a non-traditional sale, to be deemed to be bargaining in good faith if they give the tenants sort of the same terms as a third-party transaction or as a third-party non-traditional sale. So for example, if they had signed the ground lease or entered into a term sheet for this ground lease and then turned around and gave us the exact same terms, that would be deemed to be bargaining in good faith. And so in that sense, you could sort of make the argument perhaps that you could execute or enter into an agreement with somebody and then turn around and give the same agreement to somebody else, to the tenants, as part of an offer of sale. That's the only guidance, or that's the only statutory provision that I'm aware of in TOPA that really speaks to this timing issue. And again, we think that the most natural reading, once you get away from the traditional sort of fee simple sale situation is that it really is when you're in a situation like this, you have one agreement, and the execution of that agreement is really the trigger for a sale and for giving an offer of sale to the tenants.
So can we talk about this agreement? Because I have many questions about this agreement. So first of all, was it discussed in the trial court who the parties were to the agreement? Right. I mean, now we understand, I think by virtue of the briefing, that Evergreen 801 partnership, which signed the general lease with New Bethel, that they together are members of, or the parent companies of, I'm not quite sure how to describe it, Evergreen 801 Apartments. So was anybody aware of this relationship between these entities? And I mean, it sort of raises this question of, is New Bethel contracting with itself? Or is that not a concern?
Sure. So I guess a couple of points on that. One, we don't have full information about sort of the arrangement here. Our understanding, I think, at all times was that this is a joint venture between New Bethel and a developer, Evergreen Urban. I think if you look at my co-counsel Hank Brothers had sent a letter, I think, between the negotiation of a term sheet and the execution, in which he evidenced sort of this understanding that there was a joint venture between New Bethel and a developer, and that's at, I think, page 74 of the appendix. So I think we've always known that New Bethel is involved. New Bethel, as far as we're aware, isn't putting up any of the money, and we don't have any discovery or any information about what its ownership stake is in Evergreen Urban. We know that New Bethel probably doesn't have that much money, and it actually got money from Evergreen Urban as part of the ground lease transaction. But we don't think that New Bethel is by any measure of the mind like financing the development here or really taking the lead in developing it. I think in its briefing here, New Bethel has sort of said that it's on both sides of the transaction, that it has an ownership interest in Evergreen. Ultimately, though, I mean, I think there's no dispute that there is the introduction of a third party here, in the sense of both it being a different entity, but also the entity being owned by someone who is not New Bethel. New Bethel may have some ownership interest, but it is, as far as we're aware, and maybe Ms. Booth can clarify, it's not, the majority owner or even a significant owner of Evergreen.
Okay, I mean, because we're trying to look, right, ultimately, at the end of the day, pursuant to the TOPA in its current form, the substance of the transaction, right? And so it seems to me that sort of knowing who's party to the transaction is part of that, but then sort of understanding who's in control at what point in time and what is being contracted for, and who has the power to make certain contingencies happen seems important. So, I mean, at one point I saw in the record that a representation was made that Evergreen was actually the manager of the property. And then later at the same hearing, so that was at page 1023 of the third volume of the appendix. Later, sort of, there's some backtracking and a comment is made or a statement is made that Evergreen is actually the consultant to New Bethel as the manager. And so I was kind of wondering, I mean, as far as the landlord building management period, it has some sort of term of expiration. Do we know as a factual matter that it didn't expire? And, who was Evergreen vis-a-vis the tenants in Foster House, or who is Evergreen? I guess it's a current question. Is this consultancy memorialized anywhere? What are the terms of that? What power do they have to interact with the tenants? Who's hiring this tenant engagement coordinator who's communicating with the tenants at Foster House? Do we have any information about any of this?
We don't, Your Honor, and part of the problem is that we didn't get any discovery into the arrangements. We sort of got the ground lease after we filed our complaint. We've gotten some other documents through the Recorder of Deeds office, but we don't have any documents. We haven't gotten any discovery, done any depositions, gotten any emails or anything of the sort that would sort of answer those questions. I think ultimately, as I understand the arrangement, Evergreen 801 is a joint venture between Evergreen Urban, which is a developer, and New Bethel. Evergreen Urban, both I think through its own money and through the mortgage that was entered into as part of the ground lease, has some money through which it is developing development plans for the property. And so my understanding or my impression from the record and what I know about the case is that they've hired, the tenant engagement coordinators, they've hired the consultants, the outside experts to sort of develop these plans for the property. And they're the ones really leading the charge in that. I think also the ground lease itself gives responsibility for the development of the property to Evergreen. There's a whole section of the ground lease and development agreement talking about Evergreen's responsibility to redevelop the property that assigns all of those burdens to it, and ultimately, in many ways, takes New Bethel out of the picture. Does that answer your question, Your Honor?
I think so. I mean, I guess my basic question is, do you think any of my questions matter to the resolution of this case?
I think in some sense, I mean, our position is that the case can be decided based on the terms of the ground lease alone, based on what New Bethel has agreed to as of the date of the execution of the agreement. I mean, I could understand that the court might believe that the likelihood of the contingency of the likelihood of the contingencies or of the landlord building management period ending may matter when you're looking at the substance of the transaction, and all of those questions absolutely go to that issue about how likely these contingencies are to occur. We think they are very likely to occur, and to be clear, there are two that we think are mostly relevant here. One is vacancy of the building, which is where we've spent most of our time, and that over the course of a 104-year ground lease, where New Bethel is not filling vacant units, is going to happen. The second is actually, as Your Honor alluded to, the landlord building management period actually has a second trigger for the end, which is that Evergreen itself has, in the definition of the landlord building management period, it says that when Evergreen gives notice of its intent to relocate existing tenants within the building, that will also end the landlord building management period and certainly at least trigger Evergreen's responsibility for taxes and insurance on the existing property.
Why should 104 years be the relevant timeline for assessing how likely the contingency is to take place? Why isn't it 15 months? I guess my question is why, when deciding whether or not this contingency is effectively something that's going to occur. And I think you're right, over 104 years, this building is going to be vacant. Seems fairly certain. But if we're looking at the offer of sale that was inevitably made here, why can't you say, well, look, they had a contract. The contingency was not going to, it was not going to come into play before they made the offer of sale to the tenants organization. And that's enough to say that here, this is not, the contract that was executed is not a sale. They made their offer within a reasonable amount of time after executing the agreement. Does that make sense? I understand you don't agree with it. I guess, does that make sense? Does the question make sense? Well, why we don't view the contingency in terms of when the offer of sale was already made and whether or not it was likely to come up prior to that?
So if I understand your Honor's position, you're thinking that they could issue an offer of sale at any point, after the execution of the agreement until the contingency.
Not a position, just a question. Why not say, when assessing whether or not, if I sign an agreement that says, look, we're going to have an option to buy this thing before, the 2030 presidential election. I'm sorry if that's not actually 2032, I guess. I've got a contingent right to buy it at that point. And then in 2029, they make the same offer of sale to the tenants. There's no chance of that contingency coming into effect prior to the offer of sale. And I just wonder why we think executing an agreement that has a contingency that will take place at some point in the further necessarily triggers an obligation to make an offer of sale, rather than, what strikes me as a perfectly plausible view, you need to make the offer of sale prior to the contingency coming to fruition. or standing a reasonable likelihood of coming to fruition or something like that.
Sure. Not to be cute about it, but I think we care about it because that's what the statute says. And I think one thing that's actually interesting in Your Honor's hypothetical is if you go way back to the late 80s and when the council started down this path of amending TOPA to sort of expand the definition of sale, that was the sort of transaction it had in front of it, right? In I think it was 88, George Washington University entered into a master lease under which it sort of took certain features of present possession, but it also included an option to buy the building at the end of the 10 years. And the council made very clear that, and by the way, that lease also was sort of subordinate to the tenant's right to purchase or right to exercise its rights under TOPA before George Washington University could actually buy the building. And the council basically reframed it and said, we don't want the tenants to have to wait the 10 years until George Washington has the right to buy the building. We want to do that now. We want to make that a sale in present terms. And part of the reason that might matter is that it's two different sets of tenants, right? I mean, if you look at the tenants today, it might be a very different group of tenants between now and a year, 2 years, 3 years, 10 years from now, or whenever the contingency occurs. And I think what the council is really getting at is when the landlord is in a position where it's sort of giving up certain indicia of control of the building, it has to give the tenants the tenants who are in the building at that time, the right to sort of take over the building and determine the fate, rather than sort of be in this limbo where there will be a developer kind of in the picture as has been here for the last 3.5 years.
So
Focus
can
on two contingencies. And I just want to make sure your opponents, with respect to the contingency of the building being the building becoming vacant, your opponent's argument is that's never a TOPA problem because there's just it fits together very nicely. Because if that happens, then there are no tenants who have TOPA rights, and so their view is if I own a housing accommodation and I execute an agreement that says I'm going to sell it to Judge Easterly, if and only if the housing accommodation becomes vacant. Your opponent's argument is, how could that be a TOPA problem? By the time when the contingency occurs, by definition, there are no tenants who are in a position to have TOPA rights. So obviously you think that is a TOPA violation. Some of that, and I know part of your answer is because you think the statute clearly says that. I must say I find the timing and before language of the statute pretty confusing. So assuming that the statute doesn't clearly tell us the answer to that question, why should that be the answer to the question that a contract like that is a violation of TOPA?
Well, just to not lose sight of the second contingency, there is this unilateral right of Evergreen to end the landlord building management period early.
Understood. I'm just focused on the first.
I mean, I think the main concern here is that sort of if you look at kind of what's going on the ground here, what's happening is now the landlord has the incentive to actually empty the building so that Evergreen can take it over. And in that situation, it absolutely is a concern of TOPA and was a concern of the council that the tenant sort of be allowed to determine the fate of the building at that point, not sort of sit around in limbo while the landlord fails to make basic repairs, and do things so that the building becomes vacant and the contingency can then sort of be triggered and Evergreen can take over the building. I mean, it is a concern because obviously, the point is that the point of TOPA is to strengthen tenants' bargaining rights in situations like this, where the landlord has sort of decided it wants to give up control of the building.
we go back to the first contingency though, right? And that is that the landlord building management period ends when Evergreen gives notice of an intent to move people within the building, which I'm not quite sure I understand what that means, but put that aside for a second. That only transfers obligations such as, maintenance, paying the taxes, paying the insurance. Is your position that the transfer of those responsibilities under the TOPA statute is in substance a sale? Or is your argument that clearly, why else would Evergreen want to assume all of the burdens of ownership without getting the benefit of a leasehold? So clearly there's something else going on here, and we just don't quite know what that is yet.
Your Honor, I guess with respect to that particular provision, I mean, you make a good point in that it's all very unclear. There is this sort of provision in the definition of a landlord building management period about notice of intent to relocate tenants. There's no provision in the ground lease itself that sort of speaks to what that means or what exactly Evergreen's rights are under that. And that's, again, something that we would obviously want to do discovery about had we been given the opportunity. I think you're really hitting kind of the nail on the head, which is the transfer of management and all these other responsibilities are things that have been considered by this court, for example, in the Columbia Plaza case, as indicia of a sale, even setting aside sort of what TOPA itself says. But yes, I think the point is that when these obligations are transferred under the lease, that is showing that Evergreen has a certain amount of control over the building, such that it's fair to sort of treat it as a sale under the statute.
Okay, but it's not, you're not equating it with 2.1 in the actual transfer of the premises upon becoming vacant, right? Like those are distinct.
I think that so again, it's a little bit hard to say because the ground lease doesn't really speak to what happens when Evergreen gives its notice of intent to relocate tenants within the building. I think a fair reading of the ground lease is that at that point, Evergreen would have the responsibility for taxes and insurance, which are two of the 6 factors under subsection B, and it also has responsibility for maintaining the property, which could be relinquishment of possession which is another factor. If you look at the Columbia Plaza case, that was one of the things that it sort of highlighted. And so then we'd have 2 or 3 factors under subsection B, and so that would be enough to sort of satisfy the some but not all test under the statute. Does that answer your question?
Yes. So I think we are over your 5 minutes allotted. So we will move on to counsel for Amiki.
Good morning, Your Honors, and may it please the court. My name is Mel Zond. I work for the Legal Aid Society, and I represent Amiki in this case. Amiki are here today because this case isn't just one isolated transaction. It fits into a decades-long project by real estate developers to construct increasingly tortured transactions to evade TOPA. Over the years, developers have used ground leases, option contracts, and multi-step transactions to just try to disguise sales of housing accommodations. This ground lease is just another attempt to disguise a sale, but this attempt fails for the following reasons. As this court has pointed out, when determining whether a sale has occurred for the purposes of TOPA, the court should focus on the substance of the transaction. When deciding whether the substance of the transaction is in fact a sale, the court should examine the transaction in light of the factors identified in subsection B that we've already discussed. These factors are guideposts that help us determine when a sale has occurred. It's important to remember that these factors are illustrative, not exhaustive, as the statute explicitly states, when it says that the term sale includes, but isn't limited to these listed factors. In this case, by looking at the substance of the ground lease as a whole, we know the ground lease is a sale for 5 main reasons. First, the length of the ground lease, it's 104 years. Second, it immediately transfers control of the appurtenant land to the housing accommodation. Third, it also transfers control of the residential building itself to Evergreen as soon as the building becomes vacant and possibly upon notice of intent to relocate. As we discussed, it's a little ambiguous on that point. Fourth, after the initial building management period, it requires Evergreen to pay all the taxes on the property. And fifth, after the initial landlord building management period, it also requires Evergreen to be the primary insured for the property, naming the landlords the additional insured. To the extent that this court finds any ambiguity in TOPA's definition of a sale, the statute tells us how to construe the definition of a sale. The statute should be interpreted in favor of protecting tenant rights. The purposes of TOPA favor resolution of ambiguity by the hearing officer or a court toward the end of strengthening the legal rights of tenants or tenant organizations to the maximum extent permissible under the law, as section 42-3405-11 points out. This court has recognized this principle in a number of its cases, including William J. Davis and Richmond Towers. As this court noted, for example, in William J. Davis, both the plain language and the legislative history of TOPA leave no doubt that the rights of tenants are paramount in relation to those of others. And in Richmond Towers, the court reaffirmed that the primary goal of TOPA was to avoid the erosion of affordable rental housing, discourage displacement of tenants, provide tenants opportunities for home ownership, strengthen the bargaining power of tenants, and encourage the formation of tenant organizations. Throughout TOPA's history, council has repeatedly reaffirmed its intention that the substance of the transaction govern when deciding whether that transaction is a sale, and that any ambiguity should be interpreted in favor of furthering these policy goals. As Mr. Konopka pointed out, as early as the 1980s in the West End case, when parties signed a 10-year lease agreement, including an option to purchase at the end of those 10 years, council swiftly acted to clarify that such a transaction was meant to be a sale under TOPA. Once again, in 2005, when real estate developers were using multi-step real estate transactions to transfer ownership of the holding companies that controlled housing accommodations, council again amended TOPA to once again emphasize that these transactions should be looked at in a whole as to their substance, and that these kinds of transactions met TOPA's definition of a sale. Time and time again, council has reiterated the transactions should be judged by their substance, and in the case of ambiguity, this court should find in favor of tenants' rights. In this case, New Bethel and Evergreen have acted to transfer control of Foster House, introducing just enough contingencies into the agreement to make it look formally distinct from other transactions that this court has previously dealt with in the context of TOPA. However, this court should recognize the transaction for what it is, which is in fact a sale. I'm certainly here prepared to answer any questions that this court may have on the subject. But those were the main points.
I have one sort of broader question, which is, obviously the TOPA statute has limits. And so, I think that the defendants in this case have been very open in saying, yes, we were trying to structure this transaction so that it wouldn't trigger TOPA rights. And they would say, we're trying to stay within the law. We're trying to act lawfully. But it sounds like the argument that you're making is no, you should sort of apply some presumption that they're acting illegally and hold them to account for trying to evade TOPA rights. And there is an argument that look, you look at the law, you look how it's structured, and you try to structure your transaction so that it doesn't trigger the law. And what's wrong with that?
I think you're right, Your Honor. I think in this case, they certainly did attempt to introduce just enough changes to make this look different from sales that we've seen in the past, where this court has found sales before, like Richmond Towers. However, in this case, if we look to the actual substance of the transaction, what's going on here, it looks like a sale like any other sale. It's transferring control both of all the appurtenant land. It's transferring control of the residential building as well. It's transferring the burden to pay taxes, to take out insurance on the property. It looks like a sale. It acts like a sale. And the TOPA statute is clear that we should look to the substance of the agreement. We should look to it in its totality to determine whether or not a sale has occurred in this case.
So if I had a house and I had tenants in that house and somebody came and offered me, double what my house was worth, and I said, look, that's a great deal, but one thing I'm not going to do is oust my tenants. I am both, savvy enough to know that TOPA precludes me from doing that, and I like my tenants, and so I'm not going to culminate this sale. I'll sign the contract with you and we'll just set it at double whatever an appraisal comes in whenever the sale is completed. But it's not going to be triggered until these tenants leave or pass away. And, that would be, in a sense, structured to evade TOPA in the sense that I'm not making an offer of sale to my tenant. But in another sense, it is structured to really protect the heart of TOPA, the tenant's rights to stay and not be ousted. So I guess which do you think the scenario that I gave you, you think that sale would be, that would trigger TOPA rights if I had made that agreement and said, there's no way the sale is going through until the tenant leaves? You think still that triggers TOPA?
Yes, Your Honor. I mean, taking apart the exception for single family homes and, what we don't know about the scenario, but yes, Your Honor, that would trigger TOPA. And I think that's precisely because council is trying to accomplish not just one, but several different policy goals through TOPA. One goal is to discourage displacement and make sure tenants can stay in their home. But another goal is to give tenants some amount of bargaining power over the future of their homes, over who owns their home, about potentially their own opportunity for home ownership. Those are all inherent in council's reasoning for passing TOPA. And while the scenario you gave may accomplish one particular policy goal of at least allowing them to stay in place, it doesn't address those other array of policy goals that are inherent in TOPA.
I guess what I'm trying to get at, let's just say that there's, the owner, the seller is, really acting in good faith and really trying to do right by their tenants, but at the same time has just seen enough TOPA cases that they say, I am going to stay out of that procedural rigmarole that might drag me through court processes for the next couple of years. It sounds like, you think evading those processes is basically undermining TOPA, even if the seller is kind of trying to maintain faith with the core interest that TOPA seeks to protect. But I guess one answer you're giving is, well, there are other interests rather than just keeping the tenant in their homes. One is to give them some bargaining power. And although I'm not sure, where is that? That's not in the where is that in the statute?
Yes, Your Honor, it is in the statute. It's, I believe, let me pull up that language. But the statute itself does refer to giving tenants bargaining powers, as has this court in cases like Richmond Towers. The court has actually cited directly to that language.
Can I ask you, if in Judge Deahl's hypothetical, assume you're right that that's subject to TOPA, then, but imagine that's what he wants to do. I assume that is the way that would work. He would, find a third party. One way it could work is he finds a third party who's willing to purchase under those circumstances, and then he goes to the current tenants and he says, current tenants, if you want to be like the third party in that when all of you are gone, any one or more of you could be the purchaser, then go ahead and tell me that now. Is that how it would work if you want to have a transaction like that, or are transactions like that just not possible?
I think transactions like that might be possible as long as some kind of offer of sale is made to the tenants and the owner complies with all the strictures of TOPA. It is important to remember that TOPA actually provides tenants with two distinct but related rights. One is the right of first refusal, where they could potentially sign the exact same agreement as the third party purchaser. The other is the right to negotiate a separate agreement with the landlord. And that's a distinct, but of course related right. TOPA provides both of those rights to tenants. And in the scenario you suggested, it might be that the tenants take advantage of the offer of the right of first refusal in this case and sign something identical potentially to what was offered to the third party purchaser, or they may negotiate some other deal with the owner. They may ultimately turn around and negotiate an assignment agreement to the third party purchaser, or potentially even an assignment to another purchaser that makes them a better offer. Those are all very typical ways that TOPA can play out, but they do have to at least be given that offer. And that was what was denied to these tenants in this case. And I do just want to note, I believe the language that I was pointing to before is in 4234.05.11. So I believe that is the section of the statute that speaks to the purposes of TOPA. And I can confirm that in my notes. It would be helpful.
All right. Well, thank you, Mr. Zond. And we will now turn to Ms. Booth. And if you could mute your mic. And same for you, Mr. Konopka.
Thank you, Your Honor. Gwynne Booth, I'm here on behalf of New Bethel Baptist Church Housing Corporation Incorporated and Evergreen 801 RI Apartments LLC. I'd like to start by briefly responding to amici, just because I feel that the response there is more direct, and we can just address that now. When you hear my arguments based on the actual facts that have occurred in this case, you're going to see that this really isn't a case about policy. The facts are what they are, and it's clear that the ground lease is not the sale of a housing accommodation under TOPA. However, if we are going to bring policy arguments before the court today, what amici has failed to bring to the court's attention is that the policy of providing affordable housing is more important than the policy of providing TOPA rights. Now, under the ground lease, what is happening? Evergreen is being tasked with building a new building on unused land behind Foster House.
And where do you discern the fact that the policy of providing affordable housing is the highest policy? And why aren't the TOPA rights connected to the policy of providing affordable housing?
These would be statements recently from the DC Council. So as recently as July 7th, 2020, there was a committee report released on Bill B230074. That bill was entitled the Low Income Housing Tax Credit TOPA Exception Act.
Okay,
And the
but
legislative-
we're interpreting the statute that exists right now. So to the extent that you're relying on statements made in hearings before the council at some recent point in time, why should we look to that?
I think because it's important about what the DC Council's priorities are. So in the bill that I was
Well, it's
just
what their priorities
referencing-
might be going forward. But like I said, we're interpreting the statute as exists on the books currently.
Right, and TOPA's statute as a whole pushes for the provision of affordable housing. And that's exactly what's happening here by the ground lease. Foster house is remaining.
Well, it pushes
as
for a
it
lot of
stands.
different things. It's
Absolutely.
No,
Your Honor.
it has a statutory purposes provision that's 423401.2 that has 7 different purposes.
Correct.
So, there are a bunch of different competing concerns that we're trying to balance here.
Absolutely.
But
And the
maybe
only point-
maybe it would be more helpful to talk about what happened here and the ground lease that was negotiated and signed between your clients. Can we talk about the landlord building management period?
Certainly, Your Honor.
So the landlord building management period is a defined term. And it says it means the period from the effective date of the agreement until the earlier of when the existing building becomes vacant and unoccupied. And B, the tenant provides notice to the landlord of its intent to relocate existing tenants within the existing building. First, within the existing building, so Evergreen could move tenants around within the Foster House building. Am I understanding that language correctly, or am I misreading that?
The only way that Evergreen would be able to move.
I'm just
tenants-
asking you to tell me what this provision means, not how it could happen, but just, am I understanding that the text of this provision is contemplating tenants in the Foster House building that exists today being moved, say I have a unit on the 3rd floor and this is me being moved to the 1st floor.
That is how the provision is
That's how the
written, Your
provision
Honor.
reads. Okay.
And it only
And so-
triggers, as you
so then
noted,
my
the
next-
tax and insurance obligation.
Right, but my next question is, so it's the tenant, that's Evergreen, who, because this is during the landlord building management period, has no building management obligations at this juncture, provides notice to the landlord of its intent to relocate tenants. What's required to provide notice of intent? Do you have to have ability?
You have to have ability, and the
Where
only
does
way you get ability,
where does the agreement say that?
that provision speaks for itself. You have to look at the ability of parties to move one another.
Do you think it speaks for
party-
itself, or do you think that there actually is a factual question here that needs to be resolved?
No,
Because this
absolutely.
seems ambiguous to me.
No,
I mean,
not to
I
me,
could
Your
say if I signed this provision, if I were the tenant, well, I would like to move people around within the building. I've provided notice of intent. And if I don't have to have ability, then this provision is triggered and I assume all the responsibilities of building management and presumably all the possibilities of control to urge tenants to do the things that I would like them to do to facilitate my development needs. No?
Well, I think the first point and the most important there is that Evergreen would not have control. If that was the situation where,
but why would, let me just stop you. Why would Evergreen contract for this if they have no rights under this? I mean, at this point, when the landlord building management period is still in effect, Evergreen has no legal relationship with the tenants of Foster House whatsoever. So why the Foster House tenants would talk to Evergreen or trust anything that Evergreen is saying or entertain any offers from Evergreen, it's completely opaque to me, because they are legal strangers at this point, unless there's something to the fact that Evergreen is the consultant to New Bethel as the managers of the building. And there actually is some relationship that is not defined in the record. I'm left puzzled by this because it seems like this provision is giving Evergreen something, and I'm not sure what that something is. Right. I mean, this is a contract, right? And these people are in it for the money, and they're trying to make this a lucrative deal for both sides, right? So they have bargained, there's a bargain for exchange here, but I'm not sure what they have bargained for.
Correct, Your Honor. What Evergreen is attempting to accomplish there is to make a scenario where if they can get the tenants to agree with one about any form of redevelopment, they can get them on board and then end landlord building management period at that point. You can see throughout the record that attempts were made. Evergreen isn't a stranger to the tenant because they were exposed.
Excuse me, I still have this question of why would the tenants entertain any sort of communication, much less offer, from Evergreen when Evergreen is a legal stranger to the tenants in the building?
Because Evergreen had been in discussions. The ground lease being signed was disclosed to the tenants before it had ever been put forth on the table. And so the tenants were aware that Evergreen had been tasked with building a building behind the Foster House. So it made sense that Evergreen would make some overtures to the tenants in case they would also want to take part of that. And attempts at that were made. You can see it in the record. You can see various presentations made to the tenants. Unfortunately, they were never able to reach that agreement, but that's why that is in the lease. It's the hope from Evergreen that maybe they'll be able to work with the tenants, and then redevelopment would contemplate something more than they're entitled to, because under the ground lease, they are only entitled to develop the separate land.
So they
that's why that's
contracted.
there.
So they contracted for a hope. And I guess that is why they get these contingencies for $0 extra. Is that correct? Right? I mean, because as I see it, there's one payment schedule under the lease for the leasehold and the contingent remainder. And if these contingencies come to pass and the leasehold for the property transfers to Evergreen, they don't pay any extra money. They've already paid their however many millions up front and their tens of thousands of dollars starting at year 6, right? So it's because it's just a hope that they're not paying any more money for it. Is that your position?
No, Your Honor. The payment in there is representative of only a leasehold interest. That leasehold interest is the same, whether there is just the lease of the property, or if the building was to later at some point come into possession of Evergreen. That's not going to change the lease payments, because the money that is contemplated there is not a fee simple transaction. At the end of the ground lease, everything goes back to New Bethel, so the value is the same.
Well, it's not the same, really. I mean, if I am leasing property on which a building is built, and I lease all of the property, but I have no right to touch the building because I didn't lease the building. And then suddenly, after I've leased it, the owner says, oh, you can have the building too. That's a huge benefit to me, right? That's a huge asset. That is added value that you're saying is nothing. I mean, I'm not quite understanding, because it seems to me that if there's only the one payment schedule, which you seem to be agreeing with me, then that payment schedule includes payment for the building, even if only on a contingency basis. Is that correct?
So the payment schedule is contemplating a development. And so the development would be different, but it's still going to provide the same benefit. So the development on the unleased land, if that building is built, that's where Evergreen is going to receive the payments. Foster house development, they're just going to be built differently is the question, but the value would still be the same. That's why two options were always presented.
Well, but that's not what the lease says, right? The lease says you get the property, Evergreen. You have a contingent right to obtain the building, right? But the vision, I mean, I agree with you. The record reflects that there was always a hope and a plan to either develop the entire property, raise the building, which they couldn't do until it became part of the leasehold, or to renovate the building, which it's entirely unclear how they would have the ability to do that if they didn't have building management authority and it wasn't part of their leasehold. But the payment schedule seems to contemplate that there's one price regardless, right? Which might be a sign of a sale if you're only paying one price up front, regardless of the value of the asset, right? I mean, it indicates that it is anticipated that the building will become part of the leasehold, because I've got to think that the building is a significant enough asset that the landowner would want the leaseholder to pay for it in a lease.
I mean, we've got to think about what's going on here. That right is contingent. It potentially could never happen. Could it happen in 2 weeks if the tenants agreed? Yes. But it might not happen for 60 years. Think about the people who are living there. They have the right to stay there.
I think we're trying to figure out how likely it is to happen, right? I mean, because there are the contingencies of like, well, when pigs fly, and then there are the contingencies of, well, if the sun rises for the next 7 days.
That's
right?
Exactly why you can't create a contingency right now as a sale.
Well, but
you would have to wait until those contingencies resolved.
Here we have contingencies that it's unclear who's in control of those contingencies, right? If I only have to give you notice of intent to move people within the building, the power of which is entirely unclear to me how I would have the power to do that. Apparently, though, there's some sort of acceptance that Evergreen does have that power. For what reason, still remains to be seen. If all I need to do that limit then gets me the management of the building, and then I can manage the building and move people around and perhaps incentivize them to leave because I'm telling them, well, Judge Deahl in Unit 2, today you need to move up to the 4th floor, and next week I'm going to tell him he has to move down to the 1st floor, and the week after that I'm going to tell him that no, we can't fix his air conditioner, and we're going to make him pay more for utilities. Then the contingencies don't seem so far away.
Well, I think you have to be careful when you're talking about Section 1BB, which is ending the landlord management building period. The only thing that triggers is the payment of taxes and the maintenance of insurance by Evergreen. So at that point, Evergreen has no ability to add the building and the land below it into the lease. So the person that is still in control of that building is New Bethel. So Evergreen can't exercise an option to add it to the lease or have possession of the building. So those contingencies are all controlled, by New Bethel from their side, but really the tenants, because the tenants are the ones who can stop vacancy.
Am I mistaken that upon the expiration of the landlord building management period, that Evergreen assumes management of the building? Is that incorrect?
I think that is correct, Your Honor. But
okay. So in addition to paying the taxes and I understand that, but in addition to paying the taxes and the insurance, Evergreen becomes the manager of the building. That's correct, right?
That's correct, but they wouldn't be able to evict tenants, et cetera, because that remains with the owner. And moreover, even if they were bringing an action as manager on behalf of the owner, the tenants are control of vacancy. That's the key takeaway here. They can stop vacancy by paying their rent and by abiding by the terms of their lease. So I think that's the real rub, is that this vacancy contingency may never happen.
And by living forever?
Well, New Bethel has the right during the 104-year ground lease to relet the property at any point. So there's nothing stopping New Bethel from releasing those units.
But your view is, if I understand it, again, back to Judge Deahl's hypothetical, that if I own a housing accommodation and I sign a contract with Judge Easterly that says, we were both executing the document today. It's subject to a contingency, which is this, sale will go into effect and legal title will vest in Judge Easterly when all the current vacant, when all the current tenants have left and there are no, when the building is vacant. And I don't make any offer to the current tenants, and I say to them, you will never get any token rights because I'm going to sell this, and you all. I'm going to wait until I would rather hold this property until all of you are dead than give you TOPA rights. That's fine as far as you're concerned, because it's contingent. That contingency, unless immortality, that contingency is not certain because, again, I could sign a contract like that, and depending on its terms, I could choose to get new tenants. So I guess it's not a certain contingency, but your view is that the contract like that is fine under TOPA.
That is absolute in my view, Your Honor, because when you accelerate that contingency that you're talking about, either all the tenants, passing away or moving out, at that point, the property is vacant. So TOPA doesn't apply. The 6 attributes of a sale don't apply at that time. So yes.
It's very confusing language in TOPA about when things have to happen. Because if you're the language in subsection A of whatever it is, 340402, if I'm recalling my numbers right, 0.02, the offer to the tenants has to be before the sale. And then if you look in B, the sale includes executing an agreement. And so it seems like I can't right now, at least some of the language seems to suggest I can't right now execute an agreement that would amount to a sale when it comes to fruition, unless I have made an offer to the tenants. But you don't think that's right. How do you fit together the words that were troubling me about having to make an offer before there is a sale and the sale referring to execution of agreement?
Well, I think in that situation, if you're talking about an agreement where there are contingencies and you're worried about when the offer would be provided, then you would view it as at execution, you have an agreement to sell and you would need to provide the offer of sale before closing. Well, in this situation, you can't close on your contract until multiple contractual contingencies occur. So if that's the situation, you would need to give the offer of sale prior to that closing sometime in the future.
And does it matter that you have some control over whether those contingencies occur?
Well, Evergreen doesn't have any control over any of these contingencies. And that's my main point with this document.
But hypothetically, would it matter if there were some sort of agreement of, well, when I agree to do X, then I will sell to you?
I think potentially like the hypothetical that the tenant association raised in their brief, where the tenant association
that I just gave you.
But you said just do something, but I wasn't sure exactly what that something was.
When I decide to wear a blue suit, I will sell to you.
I think it would be very different, Your Honor, because you're in complete control of that blue suit. So you could decide to put it on at any moment.
You would agree in that situation that I am in complete control. And so that contingency essentially falls out. Is that correct?
I would agree that that contingency you are in complete control of and therefore makes it different than Evergreen. But I would not necessarily agree that it changes the way the statute is written. The statute is written when you're looking at those 6 factors that provide for attributes of a sale. as the contingencies, happening immediately. But I do think that there's a stronger argument for what you're presenting, that if the individual is in control of those contingencies happening, that yes, it would be much closer to being viewed as a sale. But that's just not what's happening in our action.
When the leasehold entity has control over the contingency, right? I think that's more analogous to this case.
I'm sorry, I don't understand what you're saying.
Right. If Evergreen has the power to terminate the landlord building management period by expressing intent to move people, which apparently everyone seems to think it has the power to do, or to encourage people to vacate their apartments, then how does that play into the contingency?
Well, I don't think Evergreen having the ability to encourage people to vacate their apartments changes anything. That's a decision in the tenant's own hands. If they want to leave because, I don't know, Evergreen asked them to, or they were paid, that's one thing, but they don't have to leave. So they're completely in control of vacancy. So I don't see how Evergreen ever gets to control that contingency.
Can I ask one other question? Why does the TOPA offer of sale, why would a TOPA offer of sale is made to the tenants at Foster House, and a representation is made in the record that if it were accepted by the tenants, that would result in a cancellation of the ground lease agreement? Why?
That is actually in the document. So attached to the offer of sale is a form contract. And as part of that form contract, it provides for the voidance of the ground lease.
No, I understand that. I'm asking why would your position be that acceptance of the TOPA offer of sale has to result in the cancellation of the ground lease agreement, right? Why can't they coexist? Or is it some sort of an admission that the two are actually incompatible?
Oh, they could absolutely coexist if that's what the tenants wanted. If they wanted to purchase the property for $28.9 million and have the ground lease remain in effect and have Evergreen take on the building of the new building, and then at the end of their 104-year term, the tenant association end up not just with the leased property, but all the after-built improvements, they absolutely could have it that way if they wanted it that way. It's just our understanding is that that's not the intention of the tenant association, but there's nothing that would stop that from coexisting.
But the money would go to New Bethel for the ground lease.
Well, I think in that situation, I mean, that would be part of the negotiations of the parties. I mean, that doesn't make any sense. I'm sure that the tenant association, if they wanted the ground lease to remain, then they would want the money to go to them because they would be the new owner. They'd be stepping into New Bethel's position. So yes, I think that would be not a reasonable outcome and not something that any of the parties would negotiate for.
Thank you. Unless my colleagues have any other questions, we'll hear very quickly from, I believe, are we only hearing from Mr. Konopka in rebuttal? Or are we also hearing from Mr. Zond?
Just me, Your Honor.
Great, thank you. Go right ahead.
Great. I just want to say, Ms. Booth keeps characterizing this as really a ground lease for just the vacant portion of the property. And I don't think that that's accurate. I mean, I think if the ground lease were just for the vacant portion of the property, we would have a much weaker argument that this was a sale of a housing accommodation, and they could have written the ground lease that way. They opted instead to sort of include the existing building within the scope of the ground lease, at least on a contingent basis. I do want to say, I mean, if Your Honors have further questions, I'd be happy to answer them. But I did want to return a little bit to Your Honor's final question about the offer of sale and the effect of that. I mean, as we've sort of outlined in our brief, the primary case that the defendants are relying on fourth growth, we think is totally different. I mean, in our view, fourth growth is really about harmlessness and the fact that in that situation, the owner sort of closed without realizing that they had to give an offer of sale, got to the closing table, and basically gave the tenant the exact same terms as they gave to the third party, roughly contemporaneous with the actual closing of the sale. And this case is just totally different from that, right? I mean, they sort of have taken the position that they could enter into the ground lease in November of 2018 and send us an offer of sale, a year and a half later when the housing market has changed, the financing market has changed, and somehow satisfy an offer of sale with a contract that by their own terms or by their own admission, I think they're allowed to withdraw it at any point. And that just can't be the law. That would just sort of entirely gut tenants' rights under TOPA if, for example, at any point that tenant association is actually able to line up counsel and sort of go down the path of either suing or somehow enforcing its TOPA rights, and the landlord sort of maintains this indefinite option to moot the suit at any point by issuing an offer of sale that may or may not actually be bona fide. If your honors have no further questions, I'm happy to submit.
Thank you very much to all the council who appeared today. We apologize for the wait and we appreciate your time. The case will be submitted and this court stands adjourned.
Thank you.
Thank you, Your Honors.
This honorable court is now adjourned.